number with the consent of the other side. Learned counsel for the respondent.
Yes, respondent.
Consent of the other, Mr. Systema with the consent of the other side has paid for adjournment list the matter after how many?
After vacation,
It's okay.
for hearing.
After vacation?
I will to mention item
Okay,
number
okay,
10.
okay.
After vacation.
After vacation.
Quickly, please.
Item number 10, the respondent died. There are
Item
two
number 10.
respondents, 1 and 2, both of them died. One died on, Bhagwan Das died, Bhagwan, the respondent number 1,
Hmm.
died on 21st/4/2024. And
Okay.
another,
We'll allow time for substitution.
my lord.
We'll allow time for substitution then.
Yes, yes.
Okay.
I am for the,
Item number 1 and 2.
item number 10,
10.
10,
Oh, only item number 10.
10.
আগৰটো কিমান আছিল? Learned counsel, Mr. Your name?
T. Upadhyay.
B. Upadhyay, na?
Yes.
A. B. Upadhyay.
P.
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 Mr. P. Upadhyay. On behalf of respondent number 1 and 2.
1 and 2, both of them died. There are only two
What about the appellants? Who has died? Respondent 1 and 2 has died.
Both of them died. Respondent number 1 and 2 died.
Appellant is not present today.
Let it come for substitution.
After substitution. Respondent number 1 and 2 has passed away. List this matter. How many after how many days? After how many days?
Substitution, let it come for substitution.
Yes, will
Yeah.
give time. How many days?
4 weeks.
And is submitted for substitution. List this matter after 2 weeks
Yes, 2.
or 3 weeks? 2 weeks. 2 weeks. 2 weeks.
Of like.
May it please your lordship, I beg to mention item 9, lordship. I am for the respondent number 8,
Hmm.
and in this matter, respondent number 7 already died, lordship.
Hmm.
So appellant may be directed to file substitution application. I have taken consent from the appellant.
Hmm.
Item 9, I have taken consent from Mr. S.P. Chaudhary, lordship.
Hmm. Okay.
I have informed him.
So I'll allow some time for substitution then.
Lordship, yes, lordship.
Yes.
May record that I have
If you
it,
have taken consent, they automatically they will file
lordship.
for substitution. Or
only my
give a direction.
Yes, lordship, as because my information may be recorded that respondent number 7
Okay.
died.
Okay.
I will not object, only they have to file the substitution.
Yes. Learned counsel Ms. R. Chaudhary has on behalf of respondent number, which one?
Respondent number 8, I am appearing, and
8.
7 died.
Has is present on behalf of respondent number 8 and has submitted that the respondent number 7 has passed away. The learned counsel has also taken consent from the appellant,
Mr. S.P. Chaudhary,
learned counsel for the appellant, Mr. S.P. Chaudhary, for adjournment.
yes.
Full stop. Appellant may substitute the legal years of respondent number 7.
7.
List the matter after how many?
4 weeks or 3 weeks,
4 weeks.
lordship?
3 weeks.
Fixed, lordship.
4
A
weeks.
date may be fixed, lordship.
Data need you from
After vacation, any date, lordship?
16 October.
Lordship.
16 October.
Obliging.
May I please your lordship?
Hmm.
I am praying for listing an MSA appeal.
Hmm.
Praying for listing an MSA.
Court number 8.
My lord, I have a little different prayer than this, my lord, but it is in with regard to IA for withdrawal of the money, my lord. If that can be taken up, my lord, that is otherwise very small matter, my lord. Because
He has the roster. I don't have the roster with me.
It's a bail application, madam. It
Hmm.
has to be before your lordship because your lordship has already decided this matter.
No. As per the roster, I don't have the roster with me. As per the roster,
What
could you
you
guys-
Matter to
you'll have to ask the registry.
much of.
Lordship, in item 9, they are representing respondent number 2 to 6, lordship. Mr. A. Lal, she is a junior of Mr. A. Lal.
Okay. Miss item number 9, no?
9.
It add koi dibason de. প্ৰথম sentence টো পিছত add কৰি দিবা। P.
P. Gandhia.
P. Gandhia is present on behalf of learned counsel Mr. A. Lal representing respondent number 2 to 6.
2 to 6.
Apply, sir.
Item number 1, A.
May please, your lord.
इसे नया है।
My lord, I have checked it in the registry, my lord. LCR has come, but my lord, it is voluminous. So it has not been tagged because cost list was already
Tomorrow?
out. My lord, my lord. My registry-
Tomorrow or day after
Day after
tomorrow?
tomorrow.
Day after tomorrow. Okay.
Deeply honored.
LC, trial court record as called for is not received. List, issue, nalage, list the matter on. Issue nalage, 28 August.
Deeply obliged.
Item number 2 and 3 for A.
Lord, your lordship may see the last order, 15/5/2025.
Parted by me,
Yes, lord.
definitely by me. Okay. Please.
15/5/2025. The lordship will find it is submitted. The bank statement may be produced relating to the pension received by the claimant number 1. Now, whether my lord, they are ready with that. Capillan God's full pension, my lord, 14,229.
Hmm.
My lord, I copy what have been furnished to us. First, my lord, 1/4/2017. From that, first,
Where, 4?
1/4/2017, my lord.
2017.
Second page, my lord.
Second page. okay.
Second page, 1/4/2017, first payment, March 2017, drawn 14,229.
What is this?
It's the-
Drawn?
He got the pension, my lord.
Okay, okay.
Next month, my lord, continuously 14,229. No, this submission I made in view of the fact to show that there is not loss of pensionary amount. They are receiving this amount. My lord, the only thing what I must submit, that your lordship will find the pension amount is 22,000 and odd. Now, if she is receiving 14,229, now what will be the position, my lord? By deducting that amount from 22,000, from there 14,229, the deduction will be the loss of the dependency loss of her pension is concerned. Now, the learned judge, my lord, he has himself stated in the finding that she is receiving pensionary amount of rupees 22,128. Now, if she is receiving, how can you construe that this is the dependency loss? And by giving a multiplier of 7, he has calculated it. It is a sheer, my lord, miscarriage of justice and, my lord, misrepresentation of fact also. Because the fact remains, and this is the reason, my lord, I requested your lordship to pass an order. Let them file in the account statement. Then your lordship will get whether, how much they are losing. Now, as on this day, my lord,
What, according to you, the pension he is receiving without
re-
deduction is, she is receiving without deduction is 22,000?
my lord,
How much?
the loss, dependency loss, now how much they are getting, let us see, my lord. The letters they have been given. The finding of the learned judge, I will take your lordship to that.
Mm.
My lord, your lordship may kindly take our appeal, my lord. That is MSC Appeal 509 of 2022.
Mm.
The lordship may come at page 14,
Page 14, yes.
page 14.
Yes,
Now,
22,128.
from the last, your lordship will find exhibit 19
Hmm.
reveals that the claimant was receiving pension of rupees 22,128.
Hmm.
That is the last pension which is accepted.
Hmm.
The learned judge has accepted that position. She is getting this amount.
Hmm.
Now, on the next, my lord, if she is getting, then how you construe that she is incurring a loss of this amount? This is a fundamental error in thinking the entire aspect of the matter. Now, this is if this position is there and the statement which they have submitted. Statement.
14,229.
Yes, yes.
Hmm.
Now, from the beginning, my lord, they are showing.
What,
2017, 2017,
There is
14,229. Then all through, my lord, the latest your lordship will find at page 18,000. They have given the count statement up to 2018. And 2018, your lordship will find 16,558.
16,500.
Now it will be much more because the statement is up to 28/11/2018. They ought to have given the latest.
Latest.
So now, if this thing are to be construed, then my lord, whatever, if there is a pensionary law settled, that will have to be brought out. Now, unless they give the, my lord, the fresh account up to the latter current one, then your lordship cannot get it, how much they are losing. Now, let them file the fresh, the current one.
Only up to 2018 you have given?
Yes.
But Lordship, actually, our submission is that Lordship,
Oh,
that on the last occasion, we have submitted several judgments also relating to this pension amount. The pension amount is nowhere related to the claim amount. The claim amount is totally different. Legally, the pension amount, how can it come to the, this is a MSc appeal, Lordship. This monetary amount cannot be connected nowhere with the accident. There is a different loss she is suffering, and this is a government scheme that she is getting. How can the scheme be related to the accident, Lordship? Several judgment, I can provide again, Lordship, but it is in the
Yes, yes.
record.
yeah,
Let
My
them-
submission is that.
Let them, not several judgment, not real, let them give your lordship one judgment where it has been said, when you are getting pensionary amount, then also, my lord, there will have to be another pensionary amount to be paid by the insurance company. Let them give one
not
judgment.
pensionary amount, compensation can be paid.
Compensation is compensation, Lordship. and-
Accidental compensation, there is, it is not a case that we are arguing that from the accidental amount, this will have to be deducted. This is not our case. There is the fundamental error in making the submission by the learned counsel. Because now your lordship kindly say, supposing accident
You're
was
for the
occurred.
insurer or for the owner?
Beg your pardon?
You're for
No, I am for the insurance.
Insurer, which insurance?
This is the New India Assurance.
Okay.
Now, my lord, I'm giving a picture like this. Supposing an accident has occurred
Hmm.
and they have got, say, 5 lakhs something.
Hmm.
Now, from this amount, it's not a case
Hmm.
that insurance company has deducted from the pensionary amount. Let them show this is the case. My lord, I'll not submit anything. What they want to say, my lord, let us take the case, my lord. Let us understand the fact of the case because the last occasion we have submitted is a long time, so the memory has. Lordship, may kindly come to page 11. I'll show what is our case and what they are submitting. They want to submit that is a different case, not akin to the fact of this case. Now, your lordship may see page 11. Issue number 1 and 2. The down below, para 9. Your lordship got it.
Yes. Hmm.
The last para 9.
Hmm.
Claimant number 1 has examined herself as the sole witness, that is PW1, in support of the claimant's case. And she also submitted various documents for the purpose of establishing the case in their favor. The opposite party number 1 has also adduced evidence of one witness in support of their case in defense. From the evidence of witnesses and the materials brought on record by the claimants, particularly the accident information report on Form Exhibit 1, coupled with the certified copies of GD entry number so and so, dated so and so, and serial list number so and so, death summary certificate, post-mortem report. This is Sikandar Ali, death certificate, FIR so and so, so and so. It becomes quite clear and evident that the alleged accident had taken place on 25/3/2016 at Howley near Joshua Line Hotel. With the involvement of two vehicles bearing number so and so. It is also revealed from the above that regarding the said accident, a police case got registered at Howley PS as Howley PS case number so and so. Claimants have attributed cause of the accident to the rash and negligent manner of driving of the offending vehicle by its driver. Claimants have not adduced any eyewitness to the case. The documents of the police case suggest that the claimant was approaching the offending vehicle from the opposite direction. Although the relevant GD entry dated number so and so suggests that the deceased motorcycle had hit the rear wheel of the well tanker, there is no clarity from the materials available on record about the manner in which the alleged accident had taken place. The MBA reports of the colliding vehicles are also silent with regard to the damage caused to the vehicle. As such, both the vehicles are held to be equally responsible for causing the alleged accident. Since the deceased contribution has been held to be 50%, the compensation to which the claimants are held to be entitled will be 50% of the just compensation as per the computation made here below. The allegation about the rash and negligent manner of driving of the offending vehicle number so and so accordingly stands established to the extent of 50%. That being the case, and the alleged accidental death of claimants Sikandar Ali having been proved, the question now arises as to what would be the quantum of just and fair compensation and who would be entitled to pay the same. Claimants being the wife, son of the deceased have raised this claim being his legal heirs and representatives. Claimant number 2 and 3, although are the married sons of the deceased, but at the relevant time they were students as revealed from exhibit so and so. All the claimants are accordingly considered as dependents of the deceased in the present case. The opinion number 4, Rabiul Hossain, son of the deceased, filed an affidavit stating that if the entire award is given to his mother and the other claimant, then he has no any objection. Exhibit 18, pension payment order reveals the date of birth of the deceased as 1/3/52. The age of the deceased on the day of accident was 64 years, 24 days. It would be as such be appropriate to take the slot of 61 to 65 years for the purpose of selection of multiplier. As per the decision rendered by Honorable Court in landmark case number so and so, the multiplier present in the case would be 7. And the deduction on account of personal living expenses would be 1/3, considering that there were 3 dependents of the deceased. Now, what is required to be determined is the earning that the deceased was having at the time of his death. The claimants have asserted that the deceased was a pension holder and he used to earn an amount of rupees 22,128. This is a very important part now. As pension, and deceased also doing private service under Bhagwar Bazaar Committee and Bhagwar Development Committee as a secretary, thereby drawing a salary of 10,000 per month at the time of the death. Claimant number 1, wife of the deceased, although produced income certificate, but the same has not been established. As such, the pension received by the deceased is considered to be his only earning. Exhibit 19 reveals that the claimant was receiving pension of rupees so and so as his last pension, which is accepted. Now, this is the crux of the matter. Now, if she is receiving pension 20,128, then what is the loss of dependencies of her pension is concerned? There is no loss. My lord, the learned judge has accepted after seeing the exhibit 19, which is the pension pay order. And she has been receiving that amount. Even now also, my lord, 2017 onward.
Now I got your point. You are only on the loss of dependency.
Loss of,
part.
that's all, my lord.
Other compensation you are
Other company regarding conventional amount, they are entitled. That
not as a sailing.
yes. So far, my lord, pension amount, my lord, your lordship kindly visualize one thing. Now, in spite of this position, she is receiving the pensionary amount. Now, the learned judge is directed to pay again the pensionary amount. In that position, what will happen? One pensionary amount will be paid by the government, another, my lord, by virtue of illegal order of the learned judge, another pension by the insurance company. So beneficial legislation does not mean you get some order deholds the position of law. The law stipulates what you have to get, you have to get. It doesn't mean that since it is a beneficial legislation, the benefit should be given twice. Admittedly, my lord, they are receiving the pensionary amount. The learned judge given his finding very candidly. And the statement given on the last occasion, I requested, my lord, your lordship, to pass an order, let them file this statement of account, and your lordship will get that whether they are getting it or they are not getting any. So this has come, now your lordship kindly advocate that. And in, my lord, the appeals court decision, Helen Revelio, that judgment has said, supposing, my lord, I am having an insurance policy, life insurance policy, even otherwise I will get it. If I die, my lord, my family will get it. Similarly, pensionary amount, my lord, the person, if the person, when he dies, this amount will be taken over by the family members. So therefore, unless you show that you are not getting this pensionary amount, then the question of dependency loss will come, otherwise not. That is my whole submission.
My submission is simple, Lordship, that the claim does not have any relation with the pensionary. Pensionary amount is different, claim amount is different. And in item number 3, there is one more vital ground we are taking, that the 50% deduction, Lordship, the 50% deduction is illegal. Because even the police sees both the vehicles, that is a different matter. But we have, the search sheet was against the driver of the offending vehicle, not the deceased. So that 50% deduction is not, and other grounds, my learned senior has already submitted. And
So you are not arguing that he is receiving, she is receiving 22,128 as a pension. You are not.
that is, she is receiving,
Disputing.
that is, she is receiving, that is a different scheme, but
he is
we are
not disputing,
claiming
so-
something because of the loss of
One
life.
Statement.
Somebody has.
We'll conclude. He is not disputing.
My lord, that is already there in the, my lord, the learned judge has already given the finding.
Yes,
By exhibit 19.
yes, it is.
They are
there.
receiving that amount. So there is, so for pensionary loss is concerned, that is not there at all, because they are receiving it.
Okay, I'll have to ponder over it.
Yes, yes.
Now
My lord,
this, now this is a food for thought. I'll have to ponder over
Oh,
it.
yes, yes, my lord, and I'll furnish other.
This type of argument never came before me.
My lord,
That pension amount, it has come before me, but in this manner, that loss of dependency does not come.
Exactly, well, this is the point and my lord, another judgment. What did you say? My lord, one another latest decision is there.
Hmm.
I'll furnish to your lordship by giving a copy to them. My lord, if need be, your lordship, if there is any confusion, your lordship can place it once again before the court.
Yes, yes. I'll go through it, then if
My lord,
required, then
if
I
it is
will-
needed.
Yes, yes, definitely.
And my lord, I have made a written argument, my lord, it will facilitate your lordship also.
We have also submitted a written argument, Lordship.
My lord, the points, the gist of the thing I have furnished there, your lordship, it may facilitate your lordship.
The other side is another insurance company,
No, Lordship, we are not claiming.
We are the claimant. now.
claimants.
Claimants, sir. Yes.
There are some judgments here. National Insurance Company, Puspa Rana and others who have submitted this.
My lord, in regard to the submission which I have made, the lord need not go.
Go through this, okay. This is relating to 50%
Yes.
contribution. So not required actually.
It's not necessary. This is the
Then-
crux of the thing, Melody.
Luna Devi, this is your judgment.
Beg your pardon.
Luna Devi versus National Insurance Company.
No, it's not.
Who has given this? Luna Devi
We
versus
have submitted lordship regarding that,
the respondents,
yes, lordship.
pension claimant, okay.
We are the appellant, the last item.
In the item number three.
We are the appellant.
Okay, okay.
So
Very
that's why, that is why it got.
Item number 3, we are the appellant. And
Okay.
in this case, we are the respondent.
Okay. Claimants are the appellants.
Yes,
These are the
ma'am.
judgment possibly they furnished before lordships in the item number 3.
Hmm.
Now,
Item
these
number 3,
decisions,
okay.
Yes,
my lord,
sir.
these decisions are to be looked into
Hmm.
in view of the facts of the case. Those cases I have gone through, the different things, in the line of Helen Revelio.
I'll read the entire judgment.
Yes. I think I have submitted the decision of Helen Revelio, my lord.
Ellen,
Helen, if it is not there, my lord, once again, I will be furnishing it.
I have got a pronunciatory judgment.
That's a different thing, my
Then
lord.
required actually.
This is not coming into play here.
Pronunciatory judgment is not required, I don't
No,
think so.
no.
We have given a result.
Your lordship may see Helen
Oh, yes,
Revelio,
yes, Helen Rivoli.
para 34, 35. Your lordship has this.
Hmm. Okay. You are also giving,
Yes.
Yes.
you are relying in this case.
Yes, lordship regarding the pension.
Para 35, my lord, in Helen Revelio, your lordship look into para 34 and 35.
Hmm.
There your lordship will find the honorable judges, they have decided
Hmm.
that suppose an accident has occurred.
Hmm.
In regard to other benefits like pensionary benefit, insurance benefit, these are even otherwise due to them.
Hmm.
Now, if any award is made in view of the Motor Vehicle Act, you cannot make any deduction from this. You cannot say that a pecuniary advantage has come to me. Therefore, these are the amount to be deducted from the claim amount. It's not the case here. Now, it is rightly decided, and this is the law is still holding the field. That is, say, any amount a person is getting out of the accidental amount,
Hmm.
one cannot deduct the insurance amount, the pensionary amount, gratuity and all that. Because these are the amounts, even otherwise also they will get. Now, if he dies, then his
Yeah,
pension.
yes, that I have come across.
Yes, that is the crux. It has been decided in Helen
Hmm.
River.
That I have come across.
Yes.
So then loss of dependency will be calculated including that.
If you have incur any loss. Now, in the case in hand,
Hmm.
well, fact is totally different. Fact is that the learned member thought there is a loss of dependencies over pension amount.
Hmm.
Even he has referred that in terms of Exhibit 19, they have been receiving 22,128 per month. So if she is receiving, wherefrom you are saying that the dependency loss is there. So that is the fault committed by the learned judge. So therefore, my lord, my submission is that
Yes,
If-
yes, I got your point. Mr.
Yes.
In this case, I think I have gone through this case that gratuity amount as it is you will get. Then,
those things they will get.
so that should not be deducted.
That cannot,
That
even
that
otherwise
has
they are
come
entitled
across.
to.
But only this little bit of this point,
And here question is this pensionary amount. here-
one sole point, one single point that loss of
Yes, this
dependency.
is the only point, my lord, to be adjudicated.
I'll go through it.
Yes.
I'll go through it. And you're relying on which paragraphs of this case?
Lordship regarding Helen.
Huh?
Helen,
Lordship is
same lordship,
Same.
same.
34, 35,
34,
they will also rely.
That is the point in their appeal, lordship, and in our appeal, one of the vital point is that the 50% deduction.
Hmm.
The 50% was, as the learned tribunal has.
The other
discussed,
insurance company has paid or not?
No, lordship.
Okay. Oh, you're getting only
Claimant was made
50%.
liable. The claim, the deceased
Only
was
the
made.
deceased was made liable.
for
Okay.
50% and 50%.
But
However, it was
the
established
vehicle
that
with other
yes,
insurance company
because
has
it was
not been made
solicited.
liable, okay.
that is one of the vital. points.
Luna Devi you have relied
Yes,
on.
lordship. Luna Devi is looking to.
To a common judgment, I think I can
Yes,
dispose of this case.
Yes,
This pronouncement is not required, I'm
no,
sure.
not required.
Sharla Verma,
This is also not required. These
after
are-
pronouncement, Sharla Verma is
Yes.
required as it is. So I won't go through these judgments.
Not required at all, ma'am.
And Pushpa Rana,
Pushpa Rana is
Gupta is
required,
there.
Lordship, regarding the FIR and search sheet,
okay,
the 50% deduction.
Okay.
Lordship.
this is from the claimant side.
Yes, Lordship.
Hard learned counsel, দুটা case আছে দেই একেলগে. Hard learned senior advocate Mr. S. Datta for the insurer, comma, learned counsel Mr. S.P. Sharma and learned counsel Mr. H. Ali for the claimant.
Yes,
Huh?
ma'am. Want to-
For the claimant,
For the claim.
that will be better.
Yes, yes.
Insurer
Yes,
claim,
yes,
because we
yes.
have two cases,
Yes, yes, Lord.
cross cases.
Yes.
So, written arguments have been submitted for both the sides. Reserved for judgment and order. So I'll come up
Yes.
within 2-3 days.
Ma'am,
If I have any
Deeply
questions.
obliged.
It'll take
Much
place.
obliged.
কোনকিটা আসলে এইকিটা? Item 4.
May I please your lordship? This is the second appeal before your lordship. Before going into the case, your lordship may kindly see the order dated 6/5/2025, by which I was directed to take steps on the disease respondents. Accordingly, we took steps by Dasti, by registered post, as well as by usual course. So none of the respondent has turned before the court, and the report is there. And my affidavit also I have submitted as per court's direction. That may be looked into, and accordingly order is to be passed on that. Because their name is required to be inserted in the memo of appeal before starting with the appeal. So that your lordship may kindly see first.
There's an I.
No IA.
To
IA
insert
already we have filed IA.
Ah.
In that IA court directed us to take steps. We took steps accordingly. So many respondents died. There are as many as 9 respondents, and out of that your lordship may kindly see respondent number 1. Respondent number 1 died, then respondent number 3 died, respondent number 5 died, and 6.
1, 3, 5, and 6.
Yes, your lordship. And office note dated 9/6/25 may be perused. Where
Yes,
it is
one,
already.
yes. So they have been substituted also.
Petition for substitution was filed, and then court issued to issue notice on them. Accordingly, we took steps, and steps were taken by 3 process: usual course, by affidavit, by Dasti. But they have not done. They have not received. They have refused. Report is like that, and petitioner was directed to take file affidavit in this regard regarding Dasti. So Dasti also they have refused. We personally, appellant went and to serve notice of the court, but they refused to accept. Accordingly, to that extent, we have filed affidavit. So that.
So it is deemed to be served then.
Yes, your lordship. That is,
When they have refused and you have filed an affidavit,
yes.
it is deemed to be served then.
Yeah, so that order is required to be passed first,
Okay.
and their name are to be inserted in the memo of appeal.
I think it has already been, I don't know. Here's one amended memo of appeal marked as X in this record. So on death of Murad Imam and his legal, Murad Imam, his legal heirs,
Yes,
that it has been amended and inserted.
that is appellant died. That is appellant. Murad is appellant.
Hmm.
Because appellant also died, Your Lordship.
Okay, okay, oh, sorry. This is the appellant, not the respondent, yes, correct. So now you're talking about the respondents.
Your Lordship. As per order of the court.
Hmm. On death of, so this is respondent number 1.
Yes,
This is
Suleiman.
amended on death of Mohammed Suleiman Sheikh, his legal heirs.
yes,
Respondent number 1.
yes, Your Lordship.
This is amended.
Yes, amended.
And yes, amended. I have seen the amended plain here. Amended, sorry, amended memo here.
Memo.
Hmm.
That I was directed to file. So we have filed it. A court's order may be perused, that will clear the everything.
Okay, okay. Also, which page?
Your Lordship.
Which date? Which date?
Court order, Your Lordship,
Miss question.
6/5/2005 in Miss case. In Miss, no, it is in RSA. RSA 23. RSA.
Main case.
Main case.
Appeal.
6/5/2025.
Hmm. So you have filed affidavit of service.
Yes, Your Lordship.
What is the
It is
affidavit
there.
of service to? Ekon negi boy?
As per office note dated 9/6/25 were
No,
reflected.
लिखा আছে। हाँ। An affidavit on behalf of the applicants to bring out certain information regarding service. Corresponding. 1A.
I said. Your Lordship, order dated 9/6/25 will clear the thing. Where it is reflected that we have filed affidavit and regarding other service also. Office note, that is.
There's a slight error. Actually, it ought to have been 1.1. Is it a 1A to D? 1.1, 1.4.
Your Lordship, what happened when the order was passed? No. It was we in our petition wrote as 1A, 1B, 1C like that. But the court part there was a 1 point like that. We were not aware about the thing. And that order was actually uploaded very lately. But we were directed to take steps within 2 days. So hurriedly we took steps. Because otherwise court will say that why you have not taken step within time. But in the afterwards, after taking steps and when the court order was uploaded, we found like this. So we were helpless. So it is okay. It is no problem there. 1A, 1, same thing. Only because in our petition, it was 1A, 1B, 1C. But dictation given to steno 1.1, like we can't say.
I'm sorry, but you have filed an amended petition also.
Yes, that was court asked us to file. Simultaneous.
There you
Simultaneous.
refer to them as 1.1, 1.2, 1.4 like that. In that manner.
I can, then if your Lordship direct me, I will file again. I will file again.
In what manner?
As per court's order. I may be directed, you file like this, I will do that. Because when we filed this thing, that the order was not uploaded. I should not say, but the steno was some problem, was unwell or like that. She could not upload, and then she said, you took step, others court will put a fine on you, so better you take steps. We took steps, we were not aware that it should be like this. So this was the problem with us. Otherwise, things are same. My petition is 1A, 1B, 1C. If my miscase IA looked into, It is same, 1A, 1B, 1C, 1D. IA,
Then you can file a fresh amended petition.
I can, a memo of appeal.
Oh, sorry, yes.
Memo of
Memo of
appeal.
appeal,
I can
yes.
find, I can find.
But the
As
court,
as per
but
the
is,
order date is so and so.
no, but the court's order is 1.1, 1.2.
Yes,
You have filed 1.1, 1.2, but services, no, service was on 1.A, 1.B,
yes,
1.3.
yes, that was done.
Or else you can file a fresh affidavit.
Again, affidavit one.
That 1.A and 1.B are same.
Okay,
That will be better.
yes, that may be reflected in the order.
It's for your benefit.
Yes, yes, I
It's
understand.
not,
Yes, yes.
I don't want to prolong the matter,
That
but it's for
better,
your benefit.
your lordship may give me some time and that may be reflected in the order that since I have
Same
filed
person.
like this, but it should be like this, so I may be directed to file fresh
Hmm.
memo appeal.
No, fresh is not required. You see, in court's order dated 6/5/2025, it's 1.1, 1.2 up to 1.4, and your amended petition is 1.11. But you have given an affidavit that notice has been served to 1A, 1B,
1AB, yes, yes.
So you can give a fresh affidavit that this person is 1A is 1.1. Yes.
Yes, that
Yes.
I'll do, not
So
memo,
direction is
not memo of appeal, only affidavit to clarify this thing.
Direction is not required. Actually, it has to come from you.
Yes, 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 that will do. Only 1 week time may be granted.
Yes, sure. Learned Counsel Miss
K Yadav.
A. Yadav.
K.
K. Yadav. K. Yadav is present for the appellant. Appellants and has submitted for time to file an affidavit reflecting that the notices which were served on respondent number 1A to D, 3A to 3D, and 5A to 5D are in fact served to a respondent number 1.1124, 1.3124, and 5.124. List this matter after 1 week. Learned Counsel, Mr.
I'm responded to for
2 and 7.
7.
2 and 7, Learned Counsel, Mr. R.P. Burwa, P.P. Burwa.
Yes.
P.P. Burwa is present for respondent number 2 to 7. Learned Counsel, Mr.
2 and 7.
2 and 7.
2 and 7.
And you?
Okay. Sign के पता check in और.
Senior counsel?
No.
Okay. List this matter after 1 week.
Much obliged.
My lord, I am for the appellant in both the cases.
Okay.
My lord, why to
It's for hearing, no?
hearing?
What's wrong? What about them?
My
They're
lord, senior advocate GP Bhumik is appearing, but GP Bhumik. But she is not coming to court since long, my lord. Whatever with the, my lord, case is ready as regards service, all these things, my lord. What happened in this case, to appeal, my lord,
Hmm.
there was a agreement for sale with me,
Hmm.
that is with the defendant.
But without his presence, what to do?
Mr. Bhumik is also not coming to court, my lord,
Okay. For since when?
since long time, from Corona period, he is not coming.
Last date an order was passed. So what Mr. D. Kolda? Learned Counsel, Mr. D. Kolda is appearing on behalf of Learned Counsel, Mr. G.P. Bhumik.
Yeah.
On 2/4/2025. Then The name of appellant number one was struck off.
Appellant, there are two appellant,
Ah, yes,
husband and wife.
at the risk of appellant number two.
Appellant number two is,
Yes, at the
Yes.
risk of appellant number two, and the appellant number one's name was struck off.
appellant number two is there.
Yes,
Yes.
yes.
Because the agreement for sale was between the
It's okay.
plaintiff and with the
It's
appellant
okay.
number
It has
two.
been struck off, it's okay. We'll give one last chance. One last chance.
By reflecting the name of D. By reflecting the name of D. Kalita in the cost list.
Yes, yes.
Because his name has
Last
not
time he was present.
present, but name has not been reflected in the
Cosly.
cost list. Maybe there is no Kalatnama in this paper.
Okay. Learned Counsel, Mr. S.K. Ghosh is present for the appellant. The respondent is not represented today. Earlier, Learned Counsel, Mr. D. Kolita was present on behalf of Learned Counsel, Mr. GP, Learned Senior Counsel, Mr. GP Bhumik, who was representing the respondents. The respondents are accorded a last opportunity. Without Wakalatnama, he has appeared. There's no Wakalatnama in
I
the
have
main
seen-
file.
I have
So
seen-
his name cannot be reflected. All last chance will be accorded, we will hear you. A last chance is accorded, लिखिला ना? For hearing, failing which, necessary order may be passed. One last opportunity, because the other side is not being heard also.
Both the cases.
Hmm?
Both,
Yes, yes, both the cases.
well,
Data 5 and 6 data.
date, one date maybe,
Oh, data.
because it is a long
14
pen,
October? 14 October or before that?
14 October.
When do you want? When do you want? When do you want?
October, 14 October is
14 October, 14 October.
after puja vacation.
Okay.
May I please your lordship? This matter may be passed over for time being. My senior is out of
Passover for day or time being?
pass over for time being.
Time being.
Time being. Will do.
Lordship may pass over the matter for the day. My senior, due to some personal difficulty, will not be able to.
Learned Counsel, Miss
K. Bhattacharya, on behalf of GN Sahewala.
K. Bhattacharya, on behalf of Learned Senior Counsel, Mr. G. N. Sahewala has requested to pass over this matter for the day.
Lordship, a date may be fixed, your lordship.
Okay. Learned Counsel, Mr.
I am for the respondent, your lordship.
Your name?
Yes, Ali, your lordship, it
Yes,
it
I'll
may
be
be fixed
present
on
behalf of the.
second of September, your lordship.
Is the matter on 2nd September?
2nd of September, we have a lot of matters, Lordship.
Then third, your lordship.
Third. Third is not
Third
a
is not
hearing date.
hearing day on 4th?
Only the fifth, your lordship.
No, not on 5th, on 4th.
Fourth, your Lordship.
All right,
4th is Thursday, hearing day.
four, your
Okay.
lordship.
Or Lordship on 9th, Lordship.
9th, is it a hearing day on 9th? On 9th? Are you agreeable to 9th?
9 September.
9th?
9, your lordship. It will
Okay.
do, your lordship.
9th will go.
Tuesday.
Lordship, the password for the time being, my senior jurisdiction is coming.
Okay.
My lord, 13, I am for the appellant. This matter may be taken on 16th of September, my lord.
What about the respondent? Have you taken consent from the respondent?
No response.
Is there a stay?
Yes, my lord.
Then respondent will object.
No, it is in
You call.
miscase is there, my lord, in that miscase is already disposed of at the time of till final disposal, my lord, the stay order.
Okay, on what ground? On what ground? On what ground you are asking for adjournment?
My lord, the arguing senior is some physical difficulty, my lord,
Okay.
health issue.
Learned Counsel, Mr.
I am for K.U. Ahmed, argue the matter by M.A. Sheikh, my lord.
You are KU Ahmed.
Yes, ma'am.
Learned Counsel, Mr. KU Ahmed, on behalf of Learned Counsel, Mr. M.A. Sheikh has prayed for adjournment as his senior is indisposed today. Okay then. Any objection from the other side then?
My lord, I am here,
Okay, list the
Okay.
matter on,
12 I am there, my lord, for time which is adjourned
okay,
earlier.
list the matter on 16th September. Any interim order?
Interim, my lord, in the miscase, my lord, stay petition is there, that is
Big
disposed.
case to লিখে দিবা, huh? Interim order shall. Or listing one, okay.
It is disposed of. Obliged.
Interim order নালাগে।
But respondent side is not there in my.
No, I am appearing for the respondent. Let the appellant start.
My lord, after sometimes may be taken, my lord, my senior is on legs, my lord. After some time.
start with
Just after some time.
We have urgency, lordship, both the courts
Well,
decided in our favor, so. এটা করবো,
For
after
the
some
time
time,
being, for the time being.
after some time then lordship.
Actually, he had another matter also, he's not here.
Lords.
That counsel for the appellant,
Appellant.
name, I've seen the name in an earlier matter, his junior just came and told me, is in another court.
Lordship. That's a
So we'll wait for some time then.
lordship, lordship. Obliged.
No, Lordship, this matter was fixed for hearing since six dates, and today the matter is fixed at 2. I don't know, the petition appellant side is not here. But
He'll
Lordship,
come at 2 maybe. So, if any case is ready, I'll be here. Just call me.
Lordship, I'll just inform them. Obliged.
If any case is ready, I'll be here. You just call me. Matil,
My lord, item number 8 may be kindly passed over, my lord.
today or for the time being?
Already, time being.
We have kept it,
I'm for the
we have
respondent.
held it for the time being. I am here throughout the day, don't worry.
My lord.
Oh, can we have it after vacation now?
Depends on the other side.
My friend appear.
If he has no objection, of course.
Yes,
After vacation?
take some time.
No.
Well.
Yes or no?
Yes, but it's
Or before vacation?
before
Oh,
vacation,
yes, let it be before this.
16th of September, my lord.
Item number 8. As
12,
agreed by
12.
the learned
Item number
counsel
12,
for
ma'am.
both the sides.
Item 12.
12 nahi?
Yes,
Well,
As agreed by the learned counsel for both the sides, list the matter on
16th of September.
much obliged.
Lordship, item number 16, right, counsel is here. He said at 2 he is ready to take.
at 2 or now?
At 2.
Because the council is already here.
He fixed at 2.
No, I'm ready now also, but if he has any difficulty,
But
then it's okay.
since it is fixed 2, that is why I have some. He will also take it.
Okay, at 2 then.
Obliged. Certainly, Pratama.
You do not want to wait for till 2.
No. If he has difficulty, it's okay.
See, I'm here, don't worry. If the matter is ready, I'll come back. I'm here. If the matter is ready, I'll be here.
One side is ready and the other side is missing.
As soon as the other side is free, then I'll come back. Asani, kunba ahile.
Hannan, my lord.
Learned Counsel, Mr. A.K.
Hannan.
Hannan, on behalf of Learned Counsel, Mr. M.J. Kade, with the consent of the other side,
Yes,
has prayed for adjournment. List the matter. When do you want?
on 9th of September. my
9th of September.
Highly obliged.
Item 14. Item 14. Item 14.
পাছত কৰি দিওঁ আহিব তেখেত অথনিৰ পৰা কৈ আছে তো আহিব
Yes. Appellant not present.
petitioner is not present here.
Yeah.
So petitioner was not present when we called out earlier also in the first half.
He was present.
He was present.
Took time being.
Okay, you
Senior-
wait for some time, then we will take up the other item.
Yes,
Okay.
Item 15.
Lordship, I'm appearing for respondent number 1, Lordship. Respondent number 1 has expired on 5/6/25, so we need to submit legal year certificate to the appellant.
Learned Counsel Miss
S.R. Majabir.
S.R. Mother, we have submitted that the respondent number 5, no?
Respondent number 1.
Is present on behalf of respondent number 1 and has submitted that the respondent number 5 has passed away.
Respondent number 1 has
Okay. The respondent number 1 has passed away and has submitted for time to provide a legal year certificate to the appellant
Lordship.
for substitution.
Lordship.
List the matter after 2, 3, how many weeks? 2 weeks?
2 weeks.
2 weeks.
Lords, I'm appearing for respondent number 3, NHI.
Learned Counsel Miss
And
Yane
Gogoi on behalf of C. Burwa.
and Gogoi on behalf of
L.
L. Gogoi on behalf of Learned Counsel Mr.
C. Burwa.
Standing Counsel
Yes.
Mr. C. Borua is present on behalf of respondent number
3.
3 NHAI. All right. এখানে আহিছে নেকি?
Item 16.
This is appeal, first appeal, my lord, filed by the appellant. The fact is this, there is an agreement, sale of a particular plot of land. But in long, agreement was executed in the year of 2013. The petitioner, after obtaining NOC, issued several pleader notice to come forward to execute the sale deed, they not come. Then in this way, matter has been delayed. And thereafter, they file a suit. Not for a specific Performance Act, a suit has been filed. If you also kindly see the plaint, it is page 31. This is the plaint. Page 31, my lord. This petition, plaint filed under order 7, rule 1 and 2 of the procedure code. Now, in this, against this plaint, the petitioner,
Under order 7 rule 1.
1 and 2,
Okay.
the CPC. Then the appellant
Mm.
filed written statement.
Mm.
It is page 48.
Mm. Mm. Yes.
Now let's look at this page 48.
Mm.
This is the
Written statement.
written statement.
You
Yeah.
you are the defendant.
We are a defendant. Let's look at this. One, there is no cause of action. Number two, the present suit filed by the plaintiff is barred by waiver, stable and acquiescence.
Mm.
The instance suit filed by the plaintiff is based on misrepresentation of facts. That the suit is not been properly drafted, verified and stamped.
Mm.
That answering defendant do hereby deny all the statements made in the suit, save and accept those statements which are specifically admitted herein below, and also accept those statements which are matter on records. The answering defendant do hereby denied all the statements from paragraph 12 to 30. This is the case. Now you let's look at this the plaint. If you let's look at this the plaint, the pleading case is there. It is from paragraph page 33. The pleaded case. Then so. Oh, I feel
पेज नंबर कितना मिला नहीं लेकिन 48 लगे अपन 8 स्टेटमेंट
33. It is a plain by the perfect one. It would plain by the right. It will tell the way, sir. What? Tell the head only. 29, 31
31 पे अपना की है
for plain.
What is the plaint?
mine is WS
Itu kena. Itu 31 tu. Written disturbance.
48 no itu page number
Petition this is there is a correct page annexure to page 31.
Mm.
It is a plain.
Yes. It's a plaint.
it is WS here
It will page
it is 48
Page 31 is the plaint
plain.
and page 48 is the WS.
page 31 is the WS here
Okay.
Hello?
Mm.
Page,
Yes, yes.
page 31 is the plain.
Plaint and page 48 is the WS.
And
Only that
page is the W.
respondent's file is
That's a copy of that. I don't feel like
not properly arranged.
my page 31 is the WS and
Then you see,
plaint
you-
is
You
lo-
check page 48, maybe?
page 48 is the decree I believe
Actually, I have been engaged in this case. The conducted lawyer is not.
page
available
40 is the
now.
part of the decree
The conducted
everything
lawyer
is here but page
no,
is not properly arranged
Yes.
conducted,
What do you suggest?
no I'm
Maybe-
ready if they provide me the other copy if they have or else I need to Correction to correct.
I'll make correct. This become. Let him note it, thereafter I correct. I give this to you. First you plain, you open the plain.
আচ্ছা annexure 1 আপনার plain
Plain.
এটু পেজ নাম্বার কিমান হ'ব
Now annexure 2.
no annexure 1 to plain হ'ব
That's right.
no annexure oh judgment no annexure 1 is the plain annexure 1 is the plain
Annexure 1 is the judgment, page 14. Right.
it is plain for
Plain deed with the room. I call that cancel my love. Anyway, judgment is the page 14, annex 1. My
Yes, yes,
correct.
yes.
I'm not correct. My baby. Before that, I want to, when you lost the petition, page 31, plain. That's what can be said.
My record is correct.
Yeah,
according to
yes,
your-
I will provide them.
Mm.
Okay, this is a question. Can I do?
no move to display
Second to the person is it. Another copy disable process. Then, my lord, page 33 onwards, those are the pleadings. Paragraph 5, you will clearly see. Plaintiff begs to state the plaintiff, after discussion, agreed to purchase the land, subject to spot verification, execution of the relevant documents, defendant agreed, and the plaintiff having so consideration amount of about 30 lakhs. 30 lakhs. That the plaintiff begs to state the defendant at the behest of the plaintiff agreed to reduce the mutually agreed terms and conditions into writing, and the defendant executed the agreement for sale before notarized public so 1 May 2013. The plaintiff begs to state that the date of execution of an agreement for sale, the plaintiff paid an amount of rupees 10 lakhs only, which the defendant duly received, accepted, admitted, so. Yet the plaintiff begs to state that the plaintiff and defendant have mutually agreed that as and when the amount shall be paid, the same shall be mentioned in back side of the agreement and shall be signed by the seller, I defendant. The plaintiff begs to state that the plaintiff, after having entered into an agreement, so the defendant have demanded another amount of rupees so, showing urgent financial urgency thereof. The plaintiff, in good faith, again on very next day, so paid another amount of so. The plaintiff begs to state that the plaintiff on so went to defendant to know the status of the sale permission, but the defendant informed that the sale permission is applied and the same is under process. Thereafter, the plaintiff again on so went to defendant, but again the defendant short time showing different pretexts. The plaintiff further begs to state that on so again went to meet the defendant, but the defendant assured that shown as the sale permission will be obtained. Therefore, the plaintiff and her husband again on so went to meet the defendant, and the defendant informed that the permission is yet to be obtained. The plaintiff have already paid handsome amount, have no other alternative to wait for more days, believing on the words and assurance of the defendant. That the plaintiff begs to state that the plaintiff thereafter again on so went to meet the defendant and have expressed her willingness and readiness to pay the balance amount as and when the defendant executed the final sale deed. So their case is that I have admitted the paragraph 1 to 11, and because of that, the learned trial judge has taken up the matter for summary trial, passed the judgment on admission without proof the agreement, without my lord issue firm, and without hearing my lord, and without taking any evidence. But if philosophical is paragraph 12, this is very important. I clearly denied the paragraph 12.
So adherence was not taken.
No.
It was decided on preliminary issue.
Preliminary, no,
Yes, Lordship.
no issue has been framed at
No
all.
issue framed.
No issue has been framed. Come on the judgment, my lord. No issue framed.
On maintainability.
eh,
On what point it was decided without evidence?
Because
It was, if I may, Lordship, it was decided based on their admission.
admission.
Based on their admission under
Based on
order
admission.
12 rule 6.
Because judgment has been passed on the basis of admission. Because I have not denied the allegations. Based on admission, judgment has been passed. I have come on that point, madam. Now, paragraph 12 will be most important. I have categorically denied that paragraph 12. Paragraph 12, yellow circle is paragraph 12 of the plaint, page
Yes.
35. It is very important, my lord. The plaintiff begs to state that plaintiff was under impression that the defendant will not deprive the plaintiff, being a lady, and soon sale deed will be executed. Therefore, the plaintiff again on so again went to meet the defendant, but the defendant was not in home. Therefore, after waiting for some time, the plaintiff returned back. The plaintiff further begs to state that the plaintiff again on so went to meet the defendant to know the status of the sale permission, but the defendant asked the plaintiff to wait for more few days as the sale permission is under process. Therefore, the plaintiff, on the request of the defendant, agreed that the plaintiff further begs to state that the defendant on several occasions took part payment against the balance concession amount on so and so, and the defendant acknowledged the same by putting her signature on the back side of the agreement dated so and so, stating that till 8/11/2015, the defendant had received total amount of rupees so and so. 8/11/2015. This is the last payment they say. Now, you'll also kindly see my written statement against that paragraph point.
হেৰি পঠিয়াই দিলা ন ভিতৰলৈ? টাইম লাগিব,
Time লাগিব,
মাতি দিম তোমাক।
time লাগিব।
Yes.
Now let's look at paragraph 6 of my written page 48. Details of the
Para 6 of WS.
SWS,
Page 40.
page 48.
That is page, para 6 is not page 48. Page
40,
48.
48.
Okay, okay. All right, page 48, yes.
One, there is a no cause of action of the suit. The present suit is filed by the petitioner barred by waiver.
Yes, you have denied para 12, yes.
And the paragraph 12, I received denied all the statement in paragraph 12, 13, so
Till
the
36.
plain. For the sake of brevity, sentence by the sentence denial is avoided. That the answering defendant begs to state that initial agreement that so clause 7, same provided that at the time of handing over possession of the said property, the same shall be demarcated and measured. But subsequently, the concerned authorities raised the question of demarcation before issuance of land sale permission, NOC, for which NOC was delayed, and the answering defendant are not at all responsible for the same. That in the agreement that is so, there was no written time limit specified, but it was verbally agreed upon by both the parties that the final sale deed shall be executed and registered within a period of 1 month from the date of receipt of NOC. Immediately after receipt of NOC, the answering opposite party number 1 informed the plaintiff about the same by her notice that so and so. But there was no response from the side of the plaintiff. The answering defendant number 1 also sent several notices to the plaintiff asking her to come forward and expedite the executions and registration of the sale deed, but she did not come forward to do the same. That instead of taking step for execution and registration of the final sale deed, the plaintiff tried to obtain the copy of the sale permission and NOC from the plaintiff number 1 and also attempted to sell the sweet land to other parties as higher rate, a high price, finding such malicious. This is the fact, Melon. Now, you will kindly see, if you will kindly see this is our written statement. Now, I have specifically denied the paragraph 12. This is the main paragraph. It is correct. There is an agreement. But from the plaintiff, yes, I have taken some money. Thereafter, in paragraph 12, they mention, I have completely denied. I have not taken any money.
Rupees 25 lakhs.
Yes.
Earlier, rupees 10 lakhs.
Earlier, it is admitted. It is admitted. Execution of agreement is also admitted. But from paragraph 12 onwards, I have been denied all the statement. Now you will also kindly see the judgment by the learned trial court has passed the judgment by holding that since there is an admission, he is pronounced the judgment on admission without framing issue and without taking into evidence. Page 14 is the judgment. Paragraph 1 is the history, my lord. Now, case if the defendant is also lordship has been already gone through, my lord. The lordship kindly see now. My lord. Now from paragraph 3, page 80 of the judgment. Before that, your lordship may talk about points for consideration. Since I denied the paragraph 12 of the plaintiff
Yes.
statement, so they said last payment has been made on 8/11/2015, and they filed suit. They filed suit on.
Last payment on 8/11/2000?
It is there less. It is last payment made on
No, 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 that is not, that is not the
8/11/2015.
last date, Lordship.
It
Yeah,
is-
on 25/5/2022, we have paid another amount of
No, it is- it is last
2,54,000.
para.
It is here.
It is last para, but we denied. We are denied all those. But it is beginning from paragraph 12. Beginning of paragraph 12.
Paragraph 19 of the plain.
Paragraph 18, my lord, 18 and 19, we are already denied those paragraph. So they say last payment has been made on 25/5/2022. It is their allegation. Yes. It is last payment. But we are denied. Since from paragraph 12 to onwards, all the statement I have denied. So the learned court below should have issued the frame, because I have denied, because then now question of limitation has arise, my lord. Since I denied the receipt of payment on 25/5/2012, 3rd November 2019, and 10/11/2018, all the statement has been denied.
Issues ought to have been framed.
Yes, and decide whether I have taken or not. And now question of limitation will come, my lord, because the limitation is 3 years from the date of agreement. Agreement was executed 1st May of 2013. Limitation has expired. They should have filed a suit within 3 years. Their learned court bill also did not issue frame in this regard. Did not discuss. Although I denied of that part. That part has not been denied. This is the my lord. Now we will specifically see page 18 of the judgment. Petition of association. Now because paragraph 3 of the judgment, page 18. After reviewing the evidence presented, no evidence is taken, only for plaintiff and written statement. Reviewing the evidence presented, paragraph 3. This court has determined that the defendant did not provide a specific denial of the plaintiff's allegations in the written statements. Rather, the defendants offered a defense based on certain aspects that are not relevant to the case, such the plaintiff alleged delay in executing the sale deed and attempting to sell the land to a higher price. However, the defendant have failed to specifically address the fact that they received the sale consideration from the plaintiff and executed an agreement for sale. As a result, this court concludes that the defendant's defense is insufficient to refute the plaintiff's claim. Now, analyzing the legal proceeding based on documents submitted and argument presented in this court, it is evident that the defendant in their written statement failed to provide a clear and direct denial of the claim outlined in the plaintiff's submission. Instead, the defendant restored to vague and sensu. According to established legal principle, when an assertion of the plaintiff's claim is not explicitly refuted, in the defendant's written statement, it is construed as accepted. This doctrine, known as doctrines of non-traversal, embodies the notion that any crucial statement left unaddressed is deemed admitted under Order 8, Rule 5 of the CBC. Now, therefore, in the absence of a specific denial to the material allegations, the court is obliged to consider as a acknowledged by the defendant. And this legal principle serve to uphold the integrity and fairness of judicial proceedings by ensuring that all pertinent claims and duly contested and addressed. And accordingly, my lord, the landed put below by citing some decisions and pronounced the judgment on admission. Landed court held that since I am not make any specific denial, so I admitted the claim of the plaintiffs. This is not a correct position of law because it is admitted that agreement is there, but since paragraph 12, all the statement I have been denied. Whether I have taken money, more money, I have denied all the things. So in this regard, the court is required to prove the facts. Whether I have received money,
No, but you have not denied specifically.
my lord.
It is there, no, in the CPC only.
I have also.
Every paragraph has to be.
Specifically, I denied.
Beg and
But-
receive denial
but-
to admission.
It is there in the CPC.
मैं कोई लो हाँ
Okay, sorry,
मैं तेरा
sorry,
कोई जाम तेरा तो कोई
sorry,
ये बहा
sorry.
वही तक
कोई लोग
बहा एटू के लास्ट में दोस्ता ठीक है सर तो कथा कैसे दिसे के ना
Dice aquí नहीं गिनते
दिसे एक्सपर्ट को भी तो दिसे लेस एटू सासन ठीक है समझ
Page 31 written statement.
No, no, no.
no follow yes fact that is it check with it
Page 31 is not a statement.
Page
So-
48 is.
if you also I have denied specifically
No. Not
Well,
denied specifically.
you will also clearly see my written statement again my paragraph 6. Defendant do have attended all statement. All statement, my lord. Whatever the statement made in those paragraphs,
Okay,
I have denied. All statements.
okay.
Sell
CPC
the,
won't sound you.
I will, my lord, I will discuss the provisions of law.
Yes.
Now, in the meantime, what happened, my lord, the law see my petition paragraph, some development has been arisen. When they file a suit, we entered appearance. After appearance, my lord, you will kindly see my petition, page 8.
Hmm.
Page 8, lordship kindly see.
Page 8, okay.
Yes. Before that, your
Page
lordship
8
can-
of your
my
appeal
petition,
memo.
appeal memo, paragraph 6, page 6.
Paragraph 6, yes.
You also can see if in the during the pendency of the civil suit,
Hmm.
both the parties decided amicably
Amicable settlement.
settled the matter. And agreement was again executed as a compromise agreement. Deed on 17/10/2023. Compromise deed.
Hmm.
In the compromise deed, the plaintiff also take back the money, and the defendant also agreed to return the money at a excess amount of 10 lakhs. Total 40 lakhs.
Hmm.
They say 30 lakhs. They agreed to return the money, and defendant also agreed to return the money in excess. Total amount of 40 lakhs. 5 lakhs has been paid to their accounts. After remaining amount we paid, but they blocked the accounts. We could not pay. They blocked it, intentionally blocked it. Now let's find this during pendency of this petition, that development has been arisen. Thereafter, you will finally see page 8, paragraph 9.
Hmm.
What is the nature of the order passed by the court below. It is necessary to mention herein that the record is come, my lord, you can put the record. The matter was fixed on 23/11/2023 for issue and ADR. For issue. And the matter was again fixed on 8/2/2024 for issue and ADR. And the matter was again fixed on so and so for judgment on admission. Here it is. For judgment on admission. But there is a understanding that they will place the memo of understanding settlement, the compromise deed before the court below, but on getting assurance from their side, the defendant not appeared. Think since the matter has been compromised, the suit will be closed as a on the basis of date of compromise. But that has not been done. That date facts of the matter not being on record before the court below. Did not brought it. Now moments. The first agreement was made for sale. Moment second agreement has been made in between the parties. Compromise the matter. Validity of earlier agreement ceased to exist. That agreement ceased to grant, my lord. That agreement has no longer standing. Moment the second agreement has been executed by the parties, the agreement, first agreement of sale dated 1/5/2013 is ceased to exist.
Okay.
Ceased to exist. Now, my lord, record is there, my lord. Let's may peruse those orders I referred here. Now let's look at the grounds. I have not elaborately mentioned, my lord. Already I have mentioned the grounds. Grounds number 2.
Why that second agreement will cease to exist? If the
First agreement.
First agreement, why will it?
Because party already settled the matter. Already settled the
But they
matter.
have not settled the matter.
My lord?
But you have deposited 5 lakh, they have not accepted the matter.
No, they receive it. Their account, they give the account number, we send it to their accounts.
But you have taken, no,
They receive, 5 lakhs they receive. But thereafter, we want to pay the money, remaining money on their, through their account, their account number completed by them. They block it. So we could not make any transaction like that.
No, but is there any rule that if there is a second agreement, that first agreement will cease to exist?
It is
There is no such rule.
It is understanding, my lord.
No?
It is then philosophically see. Since they enter into a second agreement on being a compromise agreement. So that will hold the fields. It is the duty of both the parties to place those before the trial court. That has not been done. That has not been done. And already they had accepted to be out of 40 lakhs, 5 lakhs they accepted. We paid through accounts. But remaining part we could not pay. But they by filing their affidavit, they admitted it. Yes, agreement is there. But since we are not making payment within 3 months, that agreement gone. It is the stand. But fact is this, matter has been compromised, amount has been received, 5 lakhs. I am ready to pay the amount within 10 days, 15 days. I am ready to give back their amounts. But they block it. This is the case, my lord. Now let's kindly see paragraph grounds. Clearly mentioned in 2, 3, 4, 5, 4 is important, my lord. 4 is legal aspect of the matter. 2, 3 is very important also. Now I read the paragraph ground number 4. For the learned 12 court will has misinterpreted and misplaced the order 8 rule 5 of the Code of Civil Procedure, so and so, and the provisions relating to passing judgment on admission. Order 8 rule 5 does not empower the court to pronounce judgment, and even the said provision does not strictly empower the court to ignore the other implications of denial as specified in the said provisions. But having done so, the learned trial court below has committed errors of law and has so and so. Now let's kindly say, for the learned trial court below, while quoting of the contents of the written statement, a max observation thereon has wrongly overlooked and ignored the denial parts of the evidence defended in passing the invoked order. Overlooked, I clearly mentioned, so we completely denied. Now, let's look at the the learned trial court will has misinterpreted section 15 of the Evidence Act, taking note of the pleadings of the appellants, and also have misinterpreted, misplaced the ratio decided in the cited case law, and thereby has arrived at the wrong finding and decisions. Now, let's look at say 7, 8 also very important. Now 9. What the learned court will have exercised power beyond its jurisdictions, the principles of law and the principles concept of Order 8 Rule 5 read with Order 12 Rule 6 of the Code of Civil Procedure, apart from Section 58 of the Evidence Act, and thereby the impugned judgment degree has been injustice and essential. Now let's look at this. Note as answer by no, I think I've got more like answer.
Yes.
Now Joseph can see Order 8
Rule 5.
Rule 5 minutes.
This is what I was talking about.
My lord?
This is what I was talking about, but you have stated that you have specifically denied.
Yes, yes. How the business? Also can you see the Order 8 Rule 5?
I've seen. This is what I was saying,
Yes,
that you have to specifically deny it, but you have stated, no?
yes,
If I have specifically
Then-
denied
then,
through para 6 of my WS.
yes.
Mm.
It's basically denied.
Mm.
Now also can you see Order 9 Rule 1. Order 9 Rule 1, my lord.
Mm. Yes. Order 9 Rule 1, yes.
Rule 1, madam. The parties to appear on day fixed in summons for defendant to appear and answer.
Mm.
On the day fixed when so summons the defendant to appear and answer, the parties shall be in attendance at the courthouse in persons or by their respective letters, and the suit shall be then taken heard unless the hearing is adjourned to future day fixed by the court. Here
Mm.
we appeared.
Mm.
We appeared and we submitted our written statements.
Mm.
Now it is the code bureau is next procedure is to be followed. Next
Mm.
procedure is to issue frame,
Mm.
take evidence, and whatever documents parties want to exhibit, make exhibits, but that has not been done. The document is to be exhibit, my lord.
Okay.
That has not been done. Now let's look and see. I order the 15. The 15. What was it? My lord, order 15, my lord.
Mm.
1, 2, and 3 rule. Parties not to issue. Where at the first hearing of a suit, it appears that the parties are not at issue on any question of law or fact, the court may at once pronounce judgment.
Mm.
That has been the issue, my lord. If there is no issue,
Mm.
then they pronounce judgment. And 2, my lord, once of several defenses not at issue, where there are more defendants than one, and any one of the defendants is not at the issue with the plaintiff on any question of law or fact, the court may at once pronounce judgment for or against such defendant, and the suit shall proceed only against other defendant.
Mm.
Parties at issue. Where the parties are at issue on some question of law or of fact, an issue have been framed, and issues have been framed by the court as before, provided if the court is satisfied that no further argument or evidence than the parties can at once adduce is required upon such of the issues as may be sufficient for the decision of the suit, and that no injustice will result from proceeding with the suit forthwith. The court may proceed to determine such issues, and if the finding thereon is sufficient for the decisions, may pronounce judgment accordingly, whether the summons has been issued for the settlement of issue only, for the final disposition of the suit. Provided that where the summons has been issued for the settlement of the issue only, the parties or the appellator are present.
Now issues are, this is not required, issues are not framed, no?
Not
It is
framed.
not required.
Not framed. This is the, I point out this point because they should have, since parties appeared, filed written statement,
Mm.
denied some specific part has
So
been,
that part of land you do not want to part with,
my lord,
the land in Beltola,
yes.
you do not want to part with the land. You do not want to deliver the possession of the land.
Now,
You want to return the money.
return them. Now agreement is there. They have executed agreement. Return the money.
But you want the land.
I return the money. Now,
You do not want the money, you want the land.
Yes, Lordship. And regarding the money part, Lordship, we have the receipt also that the last payment was made only one day prior to the limitation period of that particular agreement, because that in that particular agreement it was categorically stated there are 3 months. If they are not going to complete the payment within 3 months, in that case we can reinstate the case. We can proceed with the case. We can continue with the case. One more thing I would like to bring to your Lordship attention, that regarding the not placing the compromise deed before the trial court is concerned, this the compromise deed was executed by them. It was clearly they omitted the last page of the compromise deed, wherein it was clearly reflected that their advocate put the signature on it. They retained the original copy of the compromise deed. They are supposed to submit the compromise deed before the trial court.
now I lost see order 7 rule 2. And again, my lord, rule 2 again.
Why?
Because there is some question of law involved. Order 7, rule 2.
But this is case on specific performance of contract.
Yes,
Order 7, rule 2. Why?
that's the rule 11. my lord.
I see no
Rejection of plaint.
justification.
Power of regulate, yes, my lord. Rejection of plaint.
Hmm.
11.
Hmm.
The plaint shall be rejected in the following cases. Where it does not disclose the cause of action, where the relief,
Rule 11, no?
rule 11.
Order 7, rule 11.
Order 7, rule 11.
Not 2. Yes. Rejection of plaint, yes.
Plaints.
Hmm.
The plaint shall be rejected in the following cases. Where it does not disclose a cause of action, where the relief claim is undervalued and the plaintiff one being required by the court to correct the violation within the time to be so, where the relief claimed is properly valued but the plaint is written upon paper just insufficiently stamped and so.
See, this plaint was not rejected, no?
No, that is why. Next matter. Where the suit appears for the statement of the plaint to be barred by law. This is my case. If you philosophically see, the agreement was executed on 1st May 2013,
Hmm.
and I have admitted in that paragraph 11 up to 11,
Hmm.
2015, 2013, some amount has been paid, we received.
Hmm.
We accept it. But onward from the paragraph 12, I have denied. This one and this, I am not receiving any amount. I have denied. They should be proved. Because that is why limitation will come. Illogical is in the Limitation Act. This case fall under Indian Limitation Act, my lord, 3 years. Limitation is 3 years.
No, it's not required.
My lord,
Yes. Limitation is 3 years. I
3
know.
years.
Oh.
Yes. Limitation 3 years.
Hmm.
Since I have denied that I did not accept any money in.
Which article of Limitation Act you are trying to show?
Yes, yes.
Saw Limitation Act first. Which article?
Yes, I mark it, but. My lord, 54.
Hmm.
Article 54. For specific performance of a contract. 3 years. The date fixed for performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. Specific performance, madam. 3 years.
So your last date was 2011.
Here, it is last date, they file a suit, my lord. In their plaint, they mention, can you see page? Paragraph 9
Paragraph 9.
of the plaint, page 34. The agreement is so the defendant has demanded another amount of so on 8/10/8/2013, showing urgent financial urgency. Therefore, the plaintiff good paid again on very next day, 11/8/2013.
Okay.
I have received. Yes,
The last date, no?
last day. As per my
Paragraph
elections,
9 of the plaint.
yes. As per my case,
So
my lord,
limitation runs from?
my lord,
Limitation runs from?
runs from that day. No, limitation runs from date of agreement, 1st May 2013.
May 2013, 1st May 2013.
13.
First
3 years,
2013.
13.
So
3
3
years, 2000, May
This suit was
2018.
picked on?
22.
2022. 2022.
Okay.
So the learned trial court should have issued a frame in this respect also. That has not been done.
Okay.
Now let's look at this. Since I
So when issue is not framed, then we'll have to remand back.
yes, my prayer is remain back the matter. Already matter has been compromised. If that did compromise the matter, and I am ready to pay because their amount I did not misrepresent their amount, my lord. Because since the suit is time barred,
After
it does not mean that his money has been forbidden. No, I even more than 10 lakhs I ready to pay as per agreement, second agreement, more than 10 lakhs. Although I have not received 25 lakhs from his, that as per my conclusion, about 15 lakhs he received. Then he want ready to pay 40 lakhs.
He's not agreeing.
Yes.
No, Lordship,
Now,
I'll make my
it
point.
is
Let him make.
his agree, my agree, does not the matter. Matter is whether learned court will has correctly passed the judgment. Should at least, since I have disputed the facts that I have not received the money from 2000 after 2013, the
Okay.
suit is time barred limitations. Now that
This
judgment,
judgment, you are referring to one judgment.
one judgment,
Which paragraph?
here it is clearly mentioned, paragraph 12(6), so and so, every section has been mentioned. Now it is paragraph 37 to 44, 47, 48.
10 paragraphs, 11
paragraphs.
paragraphs.
Those are relevant, but main paragraph is Lordship can say paragraph 48. Although, my lord, my humble submissions, although the order for the court has the power, but it is not mandated in nature, my lord. It is discretionary.
There's no paragraph 48 in this judgment.
48.
No 48 paragraph in this judgment.
It is Supreme Court 2004 SCC.
2000?
2010 4 SCC.
No. You have given me another. The 2024 0 Supreme.
Supreme Court, oh, my lord, I'm sorry, my lord. I put this.
And here which paragraph are relevant?
Oh, here I
Trust and others.
will come later on that. Then maybe not. But this is my lord, I read it, paragraph 48. However, the provisions under Order 12 Rule 6 of the Code is enabling, discretionary, and permissive, and is neither mandatory nor it is preemptory, since the word may has been used, but in a given situation, as the instance case, the said provision can be applied in the judgment. If there is a clear admission, the court will think the matter whether his permission or not. It is it. It is those copy to that photograph I give that judgment, no problem, my lord. Actually, the concern he is not come with
The main
main person.
arguing for
Just I am engaged in this.
on his behalf.
Yes,
But you have done well.
well.
Although this is not your case.
Now, another decisions I will supply, my lord. AR 1999 SC 3381.
SC
SC 3381.
Party's name?
Party's name, my lord, Balraj, Taneja, and another. Versus Sunil, Madan, and I will give it. Here only question is, my lord, head note, written statement not filed. Suit can be decreed. Test, suit for specific permanence of contract. Serious disputed question of fact involved between the parties, whether defendant obtains certificate from income tax department and sends him with, to the plaintiff. Fact is to be proved by the plaintiff to show that he was ready and willing to perform his part of contract. Because suppose, my lord, I am not, defendant not appeared. It does not mean the plaintiff automatically got the judgment. Cannot. So that judgment I give, my lord, paragraph 29, 28, 29. Nine.
Okay. This is paragraph 28 to 29.
I have to get to do. My lord, earlier judgment I referred, 2024, I have not gone through it, but I found here that it is also, my lord, regarding judgment passed on education. Is also paragraph 6 of that judgment, my lord, earlier judgment. It is decided, my lord. And admission has been defined. And it is discussed order 7 rule 6. Order 7 rule 6. Whether particular statements amount to an admission will depend on the facts of case. In the case at hand, we are of the opinion that it is not an admission as visualized under order 12 rule 6. From paragraph 6, man. 2024 0 Supreme Court 813.
1, 2, 3, 4.
813.
No. This is 1, 2, 3, 4.
Oh.
Mukund Bhavan Trust and others versus Sriman Chhatrapati Udayam Raje so and so. And this paragraph 6 is nothing in this judgment.
In fact, it is a problem now. It is there.
This is not 8-1, this is 1, 2, 3, 4.
2024 0 HC 813. It is not.
No.
I'm sorry, madam. Rajesh Mitra, Rajesh Kumar.
No. This is Mukund Bhavan
This
Trust.
paragraph 6 clearly discuss about the order 12 rule 6. So, like a matter I prayed before lordships. The matter will remain back, let the issue be framed. And already they are compromised the matter. Further compromise is going on, talk is going, my client said talk is now still going on, that their claim is high now, more high. So let the my lord, matter will remain back. I have no objection at all, my lord, and since they paid the money, I am ready to pay it with double. I already agreement is there. And they also filed affidavit. In their affidavit, they admitted, yes, there is an agreement, but they claim that within 3 months we are not paid, so that agreement gone. It is not a case. Because 5 lakh I paid, they provided us their account number, where they will get the account number? If they are not given the account number, how can I get it? Then online I made payment of the 5 lakhs. And thereafter, immediately, after taking advice of legal persons, block the that account payment. So I could not make. So I request every day I request take back the money, but they did not take it. So this is my humble submission. I pray that the lordship may remain back the matter and order 8 rule A, 8 rule A and order 12 rule 2, it is I give the judgment, my lord, Supreme Court judgment. Admission. In the present case, exact cover, because there is no admission, my lord. I deny it. Because if they frame the issue from the beginning, then limitation will come, their suit will dismiss. They have no chance to get. However, second part is concerned, second pair is concerned, they in petition also, they also made alternative pair. Illustratively, I point out it. Plain, my lord. They make alternative pair also. They know the suit is tempered. That is why the alternative pair has been made. I agree. Page 45 of the plaint. Alternatively, if the plaintiff failed to establish his case, in that event, the defendant may be directed to refund the consideration amount of so and so with 10%. I already agreement is there. It is alternative. But they should have show it under specific relief acts. They did not file it. They filed it.
It was filed under specific relief, Lordship.
Under specific relief act only it was filed.
And Lordship, regarding the alternative prayer, I would like to refer section 22 of specific relief act. Subsection B, it has categorically mentioned, subsection 2.
Now, I conclude with my argument, my lord. I prayed, my lord. There is a chance of already they have compromised the matter, but I heard some person has been entered, third party has been entered. That is why matter has been now come before the this court. I love it. Itu loh Pak, আমাদের তো পেঁয়াজের নাই অবস্থা নাই।
না হয়ে যাবে নলে।
হ্যাঁ itu loh itu সব ছেলের কবি গান সব সিঙ্গে এনে দিয়েছে এটা।
Lordship, before I start, Lordship, I would like to say that regarding the limitation part, the last payment we made in the year 2022, and they have not objected they have not raised the limitation thing in their written statement.
How they will raise, no issue was framed.
Lordship, regarding the issue, I'll come to that. Before that, Lordship, I'd like to refer to the judgment. This is a written judgment, Lordship. First of all, the written is in our plaint, Lordship, we have categorically mentioned each and every date on which occasion they have received the amount. And regarding the Lordship, I'd also like to refer one legal notice, the last legal notice that your Lordship will find in my affidavit in opposition. Annexure, page number 72 to 78, Lordship. It is also there in the trial court record, Lordship. Page number 72 of my affidavit in opposition, Lordship.
Yes.
This dated 2/8/2022. Lordship, in this legal notice, we have categorically stated everything. Lordship, may kindly come to paragraph 2. That you, being the owner of the aforesaid plot of land, have intended to sell the same at the valuable consideration, and my aforesaid, on being come to know about, approach you with proposal to purchase your aforesaid plot of land, and after negotiation of consideration amount, and upon perusal of relevant land documents, the same was fixed at rupees 30 lakhs. Next para, Lordship, that you, after having fixed the consideration amount, have entered into an agreement for sale by agreement dated 1/5/2013 and have received, acknowledged the receipt of an amount of rupees 10 lakhs only as advance against the total consideration amount of rupees 30 lakhs. The first they have received 10 lakhs rupees. Subsequently, Lordship, that thereafter on 12/5/2013, you have again taken an amount of rupees 10 lakhs. Only acknowledging the same on the back side of the agreement, but has not obtained the necessary sale permission as per the conditions of the agreement dated 1/5/2013. Thereafter, you have on 16/8/2013 have received and acknowledged an amount of rupees 5 lakhs from my aforesaid client, and my aforesaid client on 16/6/2014 have approached you, but you informed that as soon as the sale permission will obtain, you will intimate my aforesaid client, and thereafter my client again on 29/10/2014 approach you. In this way, they have not obtained a sale permission till the year 2019. The first sale permission they obtained in the year 2016, which was rejected, or which was we did not agree to it because the land portion was reflected as 1 katha 4 lessa instead of 1 katha 10 lessa as per the agreement. Paragraph 5, Your Lordship. On 8/11/2015, you have admitted the total receipt of amount 25 lakhs only from aforesaid client by putting signature on the back side of the agreement. That my aforesaid client thereafter has been in continuous contact with you, which you know well, and on 3rd day of November 2019, you have received and acknowledged an amount of rupees 2 lakhs. On 2 occasions, acknowledging the same on the back side of the agreement, stating the remaining amount of rupees 3 lakhs only is to be paid prior to execution of the sale deed. That on 26/12/2019 have received an amount of rupees 50,000 only against the remaining amount and admit and acknowledge the same. That thereafter my aforesaid client have again on 25/5/2022 have paid you an amount of rupees 2,65,000. So and so only out of which an amount of rupees 2,50,000 against the remaining balance consideration amount of rupees 15,000 for necessary expenditures for registration of the sale deed. Does my aforesaid client have fully paid you the total consideration amount in performance of his part of the contract, and it is you who, after having received the full consideration amount, have yet to execute the final registered sale deed in favor of my aforesaid client. Now, Lordship may kindly come to paragraph 9. That my aforesaid client, after having paid the full consideration amount, have served you the demand notice through her counsel, stating the detailed fact about you to execute the final sale deed in pursuance with the agreement dated 1st day of May 2013. But instead of executing the final sale deed, you have sent the letter, and thereby unnecessarily delay have been caused. It may be mentioned herein that by your mobile communication, you allege to have obtained the necessary sale permission and have sent photocopy, but without reflecting the NOC number on other details. Lordship, in this reply, we have also annexed. In this, we have also annexed NOC, page number 70. Your Lordship will find. This is the NOC which they obtained in the year, which was rejected on 21/7/2023. Now, Lordship, may kindly come to their reply.
NOC relating to?
NOC, this is the NOC they obtained in the year 2000. They applied the NOC for sale permission. They applied in the year 2019, and the same was rejected in the year 2023. Now, Lordship may come to their reply. That is at page 77. This is a reply to this legal notice.
Page?
Page 77, Lordship, Annexure C of my affidavit in opposition.
Yes.
Lordship, may kindly. I acknowledge receipt of your notice dated 2/8/2022 and delivered on 6/8/2022. Frankly speaking, I am confused about the fact on whom Srimati Aloka Dutta has entrusted upon her solemnly authority, since I have already responded to a similar notice served upon me by another lawyer by the name of so-and-so. However, responding to the legal notice served by you, it seems content of the letter more in line with an account statement than anything to do with settlement of the dispute as portrayed by Miss so-and-so, wife of so-and-so. Now, the situation is precipitated by Aloka Dutta and her previous lawyer in becoming a very complex and untenable. The fact of the matter is, there has not been any issue with regard to financial transaction until the time Aloka Dutta and her husband Biren begged around for finance in the vicinity of said property, resulting in involvement of numerous fringe elements. Now, this part is very important, Lordship. I, being a retired woman with respectable family background, will never get involved in such situation and never deny whatever amount payment received over the years in cash and check and dishonored blank checks. Whatever amount we have mentioned in our legal notice, they have acknowledged it. And we have placed it before the trial court also. It is also there in the trial court. I am enclosing here with documents pertaining to communication and chronology so-and-so until the day when so-and-so and her lawyers created a situation which partified me in the lawyer's chamber, where we were going through the proceedings of the land registration agreement, and is evident from the enclosed copy of the printed stamp paper. Now here, Lordship, now that the NOC from district authority expires its validity, and I have no intention to further get involved in any agreement with your client anymore, and I will only request you to advise your client to agree for refund of whatever amount was paid to me over the years in a amicable settlement. Lordship, she first of all, she acknowledged that she have received amount till the year 2022, whatever we have mentioned in our.
Where she has acknowledged?
Yeah, she has acknowledged, Lordship. I being a retired woman with respectable family background will never get involved in such a situation and never deny whatever amount of payment received over the years.
This is not acknowledgement.
This is not expressed but implied. This is, Lordship, she acknowledged.
Think about how I'll get into implications in a reply. This is a reply, not
Yes, Lordship.
request also.
I'm only trying to highlight that we have placed this before the trial court, and in their written statement, I'm coming, Lordship. Now, Lordship, in our plaint also, whatever we have stated here, the chronology of the events, the same is stated in the plaint also, Lordship. And Lordship now Lordship may kindly come to their written statement. They refer, my learned senior friend referred paragraph 6. Here, Lordship, they have also only mentioned the paragraph numbers. They have to specifically deny as per order 8 rule 3,
Yes,
4 and 5. They have
that
to specifically deny that.
He has stated no all.
No.
In a bold manner.
I have multiple judgments to place, Lordship. I will place my judgments.
Yes,
Wherein Supreme Court have categorically stated that any statements, any vague statements which is not to the point, which has not been denied specifically, amounts to
code.
Amounts to admission.
That is already there in the code.
Yes, Lordship. It is already there.
But he has stated, no, that see, one deny all statements.
Yes, this is not sufficient, Lordship. This is not sufficient as per the provision, Lordship. Provision is very clear that statement, any abatement has to be denied specifically. And Supreme Court also time and again say the same thing. Merely just saying that 2, 12, 13, 14, we are denying it is not going to, is not sufficient.
Each and every paragraph has to be.
Each and every paragraph they has to deny categorically.
The code, yes.
Yes. And Lordship, in their paragraph 6, paragraph 5, they have stated answering deponent hereby deny all these statements. This is also not sufficient. Paragraph 6, they have not categorically denied. Paragraph 7, they have admitted that agreement dated 1/5/2013, which was executed between the parties. There were supposed to be the two issues, whether the agreement dated 1/5/2013 was executed between the parties or not. That part they have admitted here. And next part is that whether they have received the consideration or not. Now, Lordship, clause 7 of the same provided that at the time of handing over the possession of the said property, the same shall be demarcated and measured. But subsequently, the concerned authority raised the questions of demarcation before issuance of the land sale permission NOC, for which NOC was delayed, and the answering defendant are not at all responsible for the same. Here they said that due to NOC delay in NOC, they could not execute the sale deed. But that in the agreement dated so and so, there was no written time limit specified, but it was verbally agreed upon by both the parties that the final sale deed shall be executed and registered within a period of 1 month. That is, we have not acknowledged it because there were no verbal agreements. And now they refer immediately after receipt of NOC, the answering opposite party number 1 informed the plaintiff about the same by her notice dated 18/6/2022. They said that they have informed us by notice dated 18/6/2022. But last notice we have communicated with them, that is 2/8/2022. Now, Lordship, paragraph 9, instead of taking steps for execution and registration of the final sale deed, the plaintiff tried to obtain a copy of sale permission and NOC from the plaintiff, and also attempted to sell the suit land to other parties at higher price, finding such malicious and unauthorized actions of the plaintiff, and the opposite party had executed the agreement dated so and so, power of attorney so and so. Here, Lordship, they were saying that subsequent agreement, whatever the subsequent agreement executed between the parties is not in force. Now, while this agreement dated 1/5/2013 is there, they've executed another the power of attorney and sold it subsequently to the performer in favor of performer defendant number 2, 3, and 4. They have executed it. There's nothing, we did not enter into agreement with any person. It is their allegation, but it is also, it is on record that they have executed the agreement dated so and so, subsequent agreement and power of attorney, which is illegal, Lordship. Now, Lordship, here that since the market value of the suit land has been increased and many times, the objector number 1 is not in a position to sell the said land to the plaintiff at the value of land as agreed in the year 2018, and she agreed to return the money received from the plaintiff. Here she has to categorically deny that yes, this much of amount I am going to return. By saying that return the money received from the plaintiff, which we have already categorically mentioned in our plan that till the year 2022 we have made a payment total rupees 29,90,000. She categorically admitted it as per section 8 rule 3, 4, and 5. Regarding the issue framing of issue, Lordship, I would like to refer your Lordship order 14, Lordship. Order 14 rule 1.
Yes, order 14 rule 1.
Order 14 rule 1, Lordship. Regarding the framing of issues. Issue arises when a material preparation of facts and law is affirmed by one party and denied by other. Material preparations are those preparations of law or facts which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Each material preparation affirmed by one party and denied by the other party shall form the subject of the distinct issue. Lordship, I would like to place one judgment in this regard. If they admitted our whatever the avertments we have made, the question of framing issue does not arise. First of all, this is I'd like to place this judgment in this regard. This is Lordship 2023-0 Supreme SC 495. Lordship can come to head note only. Head note is same. Point number C. Civil Procedure Code Order 14 Rule 1. Framing of issues. At first hearing of suit, court shall, after reading plain and written statement, if any, and after examination under Rule 2 of the Order 10, and after hearing parties and their pleaders ascertain upon what materials, prepositions of facts or of law parties are at variance, and shall thereupon proceed to frame record issues on which right decisions of case appears to depend. Court is not required to frame and record issues where defendant at the first hearing of the suit make no defense. Here, in their written statement, Lordship, they have not categorically denied any of our avertment. Instead, they said that they will return the money, which means they are not ready to perform their specific performance. Lordship, I would like to also refer another judgment regarding Order 12 Rule 6, Lordship. Yes. Before that, Lordship, I would like to argue on additional evidence, Lordship, which they want to rely that compromise did, Lordship. They want to rely on that as an additional evidence under Order 41 Rule 27. Lordship, Lordship may kindly come to Order 41 Rule 27 first.
Now additional evidence in this appellate stage.
Oh, yes, they have categorically mentioned in their appeal memo.
No, but they have not, see, Order 41 Rule 27, it has to be adduced as evidence.
Exactly, Lordship.
But only by placing that we cannot consider.
Exactly, Lordship, exactly. That is what I am trying to show, Lordship. Here, Order 41 Rule 27, what is the criteria?
Compromise deal.
Yes, regarding the compromise which they are placing here, the criteria I would like to highlight, Lordship. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in an appellated court, but if The court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted. The party seeking to produce additional evidence established that, notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appeal against was passed. An appellated court requires any documents to be produced, any witness to be examined to enable it to pronounce judgment for any other substantial cause. Here, Lordship, first of all, there were proper hearings conducted before passing the decree, and they have not. They were in the possession of this particular compromise deed. They have executed it. In my affidavit in opposition, Lordship, I have also annexed the attested copy of this compromise deed. At the last page, it is clearly reflected that the advocate, whose name is also there in the appeal, in the Wakalatnama, he executed this compromise deed. And he retained the original copy of the deed. He's supposed to submit at the time of hearing conducted by the trial court.
Oh, wait, it was not hard, issues were not framed. How will he submit?
No, Lordship, first of all, that stage did not arise. Because whatever abatements we have made, they have admitted it categorically. I am going to place the judgment on it because order 12 rule 6, there is a power, there is a discretionary power of the court, wherein court can see that yes, there is nothing substantial questions left to be attended, they can pass judgment. Because the issue was that whether the agreement dated 1/5/2013 were executed between the parties or not. The second is that whether they have received the consideration amount or not. And they have specifically admitted it, they have not specifically denied it. Instead, they say that they are not going to execute the sale deed in their written statement. Order 8 will be.
I think this second agreement, which one you want?
Not produced before that.
Huh?
That agreement
Ah.
would have produced before the could be,
Yes,
but not
but
produced.
even if you want to produce in this court, you must file an IA. You just cannot hand over the paper like that, I think.
It's there,
Yeah.
but who can take cognizance on that basis?
There has to be something to
Because,
take it on record.
because-
Without bringing it on record, it's not possible.
If necessary, I'll do it. But
That agreement is not relevant. That is not
this
enforceable
court-
now because
this
there is
court
What
has
is,
got-
what is the second agreement about?
second compromise,
Oh, compromise.
compromise.
that agreement
They-
was not enforced. right? Because it was
They are
3 months.
ready to take back the money. I also ready to give the return the money, that agreement. And 5 lakhs they received. You also already noted it. 5 lakhs already received.
Lordship, they are saying that 5 lakhs
I
have been
next,
received.
yeah.
Lordship, 4 lakhs, they initially make the 4 lakhs payment, and it was, if your Lordship will take this compromise deed, I'd like to read the compromise, I'd like to show something. Your Lordship may kindly take the compromise deed. That your Lordship in, to blue হয়েছে page number 2. Lordship may kindly come to page number 79 of
And I will refer.
my affidavit in opposition, page number 79.
Page 79, yes.
Page number 79, your Lordship. This is the compromise deed between the parties. Whereas, Lordship, the second buyer, the second buyer is the original buyer. Second party, it was supposed to be second party, is the original buyer of the plot of land measuring 1 katha 10 lesa covered by so and so, so and so, so and so, so and so, and filed a civil suit bearing title suit so and so against the original pata holder of the aforesaid land so and so, so and so, along with the other defendants, that is first party in the instant compromise deed, who happens to be the subsequent buyer of the said plot of land.
This is while the suit was still pending, then they have.
Exactly,
executed-
before passing the
I'm
judgment.
not talking about this, that compromise.
This is the compromise deed, Lordship.
Okay,
There is no other compromise deed. This is the compromise deed.
okay.
This compromise deed was executed on 17/10/2023.
Mm.
At that time, the decree was not passed.
Okay.
They retained the copy of this compromise. They're supposed to submit it before the trial court. And there is a clear time limit of 3 months. If they are not going to complete the payment within 3 months, this it is not going to this is not enforceable anymore. It is written here categorically. And regarding the order 8 rule 5 lordship, I place one judgment. I have given one judgment lordship.
Yes, yes. Order it, rule 5, yes.
Exactly. Lordship, paragraph 15 lordship. Lordship got it?
Yes.
In the absence of para-wise reply to the plaint,
Mm.
it became a roving inquiry for the court to find out as to which line in some paragraph in the plaint is either admitted or denied in the written statement filed. As there is no specific admission or denial with reference to the allegations in different paragraphs. Paragraph 15.1. Order 8, Rule 3 and 5 CPC clearly provides for specific admission and denial of the pleadings in the plaint. A general or evasive denial is not treated as sufficient. Proviso to Order 8, Rule 5 CPC provide that even the admitted facts may not be treated to be admitted. Still, it is a discretion of the court may require those facts to be proved. This is the exception to the general rule. General rule is that the facts admitted are not required to be proved, which is also it also attacks section 58 of the Evidence Act. 15.2. The requirement of Order 8, Rule 3 and 5 CPC are specific admission and denial of the pleadings in the plaint. The same would necessarily mean dealing with the allegations in the plaint para-wise. In the absence thereof, the respondent can always try to read one line from one paragraph and another from the different paragraph in the written statement to make out his case of denial of the allegations in the plaint, resulting in ulterior confusion. Now, Lordship may come to paragraph 15.4, Lordship. The issue regarding specific admission and denial of the pleadings was considered by this court in so and so. I am also going to rely on this. While referring to Order 8, Rule 3 and 5 of the CPC, it was opined that the aforesaid rules formed an integral code dealing with the manner in which the pleadings are to be dealt with. Relevant part of the para 11 thereof are extracted below. 11. Order 7 of the CPC prescribed, among others, that the plaintiff shall give in the plaint the facts constitute the cause of action and when it arose, and the facts showing the court has jurisdiction. The object is to enable the defendant to ascertain from the plaint the necessary facts so that he may admit or deny them. Order 8 provides for the filing of written statement, the particulars to be constituted therein and manner of doing so. The last is the 15.5. I am also going to rely on this. The matter was further considered by this court in so and so. After the 1976 Amendment Act in CPC, whereby existing rules 5 of the Order 8 rules of the CPC was numbered as sub-rule 1 and 3 more sub-rules were added dealing with different situations where no written statement is filed. In 14 and 15 of the aforesaid judgment, the position of the law as stated earlier was reiterated. The same are extracted below. What is stated in the above is what amounts to admit a fact on the pleadings, while Rule 3 of the Order 8 requires that the defendant must deal specifically with its allegations of the fact of which he does not admit the truth. Lordship, which it clearly says that every abatement has to be denied specifically. And in the written statement, Lordship, they have categorically admitted that they executed the agreement, and impliedly they also admitted that they have received the amount. They are not going to execute the final salary. And that is why this judgment of the lower court is correct. The very recent judgment was passed by the lower court, Honorable Trial Court, Lordship. Now, Lordship, I would like to place judgment regarding Order 12, Rule 6, Lordship. Order 12, Rule 6, judgment for the same. Yes, sir. Yes, to this. This is Lordship 2005 Supreme 425.
Okay,
Lordship, paragraph 13, Lordship.
paragraph 13.
Yes, Lordship. As to the object of Order 12, Rule 6, we need not say anything more than what the legislature itself has said when the said provisions came to be amended. In the object and reason set out while amending the said rule, it is stated that where a claim is admitted, the court has jurisdiction to enter a judgment for the plaintiff and to pass decree on admitted claim. The object of rule is to enable the party to obtain a speedy judgment, at least to the extent of the relief to which, according to the admission of the defendant, the plaintiff is entitled. We should not unduly narrow down the meaning of this rule, as the object is to enable a party to obtain speedy judgment. Where other party has made a plain admission entitling the former to succeed, it should apply, and also wherever there is a clear admission of facts in the face of which it is impossible for the party to make such admission to succeed. Here also Lordship said that if there is a admissions, clear admission, then Honorable Trial Court has all the power to pass the judgment on admission. So Lordship may kindly look at their written statement once again. If there is nothing they deny specifically, instead they admitted that there was a deed executed between the parties. And regarding the compromise deed, the Order 41, Rule 27, Lordship, there is a category which they have to fulfill, their criteria. And this, if they want to press on this, they can file another suit. How can they come in at a later stage when without, at least they could have submitted it before the trial court, because they had ample amount of opportunity. At that time, the trial.
These they didn't have, opportunity they didn't have.
They did.
Only 3 days.
And also this agreement was meaningless at that time, because there was time bar of three months, and they have not paid. It was categorically mentioned in the said compromise deed. And we are not agree for this compromise, Lordship, since my learned senior friend has said that we are ready. We were not ready. And it was categorically stated that they approached us. In the compromise, it is also mentioned that they approached us. Just because we were suffering some financial constraint, that is why we entered into that agreement. And they without executing the final sale deed, they have executed the power of attorney and the sale deed with in the name of in favor of other persons, behind our back. We didn't know about this.
To sell deed.
Yes, they have no, deed of agreement. Sorry, deed of agreement.
Agreement, I think.
Deed of agreement. I'm sorry, Lord.
Deed of
Deed of agreement. Power of attorney and the deed of agreement. They have executed, which shows that they have the malified intention. They already received the amount since the year 2013 to till from the year 2013 to till 2022. Regarding the framing of issue, Lordship, I have already placed one judgment, wherein it is categorically stated that if one party made avertments and other party do not deny, then the question of framing issue does not arise. Because they are supposed to deny whatever the avertment, because they even why I was trying to
Receive the judgment.
this Lordship 2023-0 Supreme SC 495. I think I have given the copies.
2023?
2023-0 Supreme SC 495.
2023.
Supreme SC 495.
No. No, these are the judgments I have. Maybe, oh, just a moment, just a minute. 2023-0.
Supreme SC 495.
Yes.
Party name is
On issues, no?
Reliance
Yes, yes,
Reliance
yes.
Infrastructure.
On issues, yes.
Yes. Lordship Lordship, I am referring this point number C in the head notes, which I have.
Yes.
The framing of issues at.
Yeah, I'll get the paragraph. From the head notes, I'll get the paragraphs.
Yes, Lordship. Here it is categorically stated that if avertments has not been denied, then the question framing of issues does not arise. And it will only delay the proceedings, because I have categorically mentioned everything in my legal notice. There also they have admitted that whatever the amounts they received, they were ready to return. Here also in their written statement they have admitted, and they say that they are not going to execute the financial deed, which means because of the value of the land has been increased, which means they were not ready to perform their part of the specific performance. And regarding the this alternate remedy which we have given in our prayer, that I have already mentioned that Lordship in
It is 1 Katha 10.
section 22 of the Specific Relief Act, Yes,
Or, yes, alternate remedy? Yes.
regarding alternative remedy, Lordship may come to specific relief act section 22.
Yep.
I'm sorry, Lordship, section 20.
Hmm.
Section 20, subclause 2, Lordship.
Asani specific relief act, what? Please read.
No substitute performance of contract under subsection 1 shall be undertaken unless the party who suffers such breach has given a notice in writing of not less than 30 days. I'm very sorry, Lordship, it's 22, it's not 20. It's paragraph, it's section 22, sorry, Lordship. Section 22,
Section 22.
power to grant relief for possession partition.
Plus
Subclause B, subclause B, Lordship.
B.
B. Subclause 1B. Any other
1B.
relief, any other,
Plus 1D.
B.
Okay.
Any other relief, Lordship, got it?
Please read, yes.
Any other relief to which he may be entitled, including the refund of any earnest money or deposit paid or made by him in case in claim for specific performance is refused. Only if I was not granting decree, then I can claim this alternate remedy. This right is there in the specific relief act, Lordship. It is categorically mentioned in this provision. Therefore, making alternative prayer is not going to diminish my case, Lordship.
All right.
Therefore, my humble submission, your Lordship, would be that the judgment itself is reasonable, Lordship. It was categorically mentioned they have categorically admitted whatever the advertisements we have made. Therefore, there is no substantial questions left to be admitted, answered, Lordship.
It is first appeal, matter. It is first appeal, not a substantial question of substantial.
No,
question of law does
still
not arise.
facts, all the facts, whatever the advertisements we have made, they have admitted it, Lordship.
Article item 16, no?
Item 16, Lordship.
Heard learned counsel, Mr.
B. Kumar.
Huh? Oh, acha. Oh.
And
My lord,
regard.
Concluded. Hearing
You want to
concluded.
reply?
Yes, Ms. Conway.
Not required.
No, only one point. Regarding,
What is there to reply?
my lord, since court is my favor, I am not replying.
Oh, who has said so? I still am pondering
Yes,
which way to bend.
but only fact is, my lord, my reply,
Mm.
the second agreement,
Mm.
it has been made, they have taken the responsibility to produce the SAM.
Lordship,
Whether-
this is vague.
You also kindly see
vague
the page
submissions.
52 of page 52 of the agreement, whether you denied it, they did not deny it for the execution of that agreement. Their signature is there, they have taken
My
money,
signature is there, Lordship, may
they
kindly,
have taken the money.
if I may,
It is
Lordship,
one
if I
matter.
may, Lordship, may
Then
kindly
matter-
see,
Another matter is there.
if I may,
Order 41 rule 47, court can take cognizance, because in first appeal, I have.
only when they
I
have taken the
put a
due
policy
diligence during
by-
time trial.
By annexing the document, in the first appellate court, my lord, first
Okay.
appellate court.
Can, court can allow, but
My
there, I
lord,
think
first,
there should be.
yes, I give one judgment,
At
I give
least.
one judgment,
Okay.
it is not able, court
Why
can
not judge?
take
Lordship,
it cognizance. Under order final rule 27, my lord, court can take cognizance at any stage. Appellate
First of all,
stage,
Lord-
even second appellate stage, my lord. Now, their case is, my lord, I already stated, my lord, paragraph, onward paragraph, all statements, not necessarily specifically mentioned, my
it
lord.
is categorically
All
mentioned in
statements,
the
not
plethora of
category,
judgment of the Supreme
all
Court. Lordship.
statements.
Provision itself is enough to,
It is, if they pairwise given reply, it is different. But I say that all the statement made in those paragraphs were denied. All the
no,
statements,
Lordship,
nothing left, my lord.
that I
So
have,
what, under order 47 rule 20, under order 51 rule 27, what do you want?
What, my lord?
What do you want me to check?
Say, my lord, since they,
The second agreement.
yes.
that was infectious,
Second
Lordship.
agreement.
First of all, that was infectious, that is not in force. It was categorically mentioned in the said there's
How
agreement. And
infectious, my
and
lord?
interestingly,
It is-
Lordship,
it is
the agreement
binding.
was
They have
executed
taken-
by their advocate.
They have
We
taken,
have
my
not
lord,
made the,
they have taken rupees 5 lakhs. Trying to misrepresent.
If
it,
they
my lord.
want, if they want to,
Sitting
if they
completely
want to
sitting
press
act, my
this,
lord.
they can file a money suit before the trial court. Because
Why?
how can they infect, they press on this,
seated that way.
wherein this,
This is the end now.
My lord.
Third learned counsel, Mr.
Jai Ahmed.
J. Ahmed, for the petitioner, and learned counsel, Mr. B. Kumar,
B Kumar Lordship,
for the respondent.
for the respondent, sole respondent Lord.
Reserve for judgment and orders.
Oh, my lord, first I give the judgment, I get the copy. Paragraph, that judgment, paragraph 18 and
I will also,
point of limitation,
Which
point of limitation. It is a 2024 0 Supreme 1234.
2000,
For first I was,
2024 0 Supreme 1234.
yes, madam.
Lordship, the
Paragraph
limitation
18 and
part I don't
26.
think they right, because
Yeah,
Point
yeah.
of limitation.
The point of limitation.
they have not
Point of limitation.
obtained
It is
the NOC till the year 2023 Lordship.
It is for 12 years.
I have annexed,
Let's see.
Yes, sir.
I have annexed in my affidavit in opposition. Lordship, I will also place
Paragraph 18 and 26.
18,
26. It is a point for limitation.
I'd also like to place one judgment, Lordship, regarding the order to rule 6, the recent judgment of Supreme Court.
Only question is, my lord, paragraph 12 I specifically deny. If that issue is to be framed, so it is time barred, my lord.
case on date to give you.
Hello, my lord.
Lordship, I'll also like to place one judgment regarding the order to rule 6 and
Yes,
this is the recent judgment of the Supreme Court. Paragraph I have written in the front, paragraph number.
Get up to that.
Oh, sorry. Thank you.
Hey, correct copy पे रहना है.
Copy to पूरा page होता है.
रहना है, क्या रहना है? I am sorry, my lord, the conductor will come. He is not served the correct copy to him. Correct copy not served to him.
It's okay.
He's done.
He has done very well.
Well,
Without the correct copy.
yes, ma'am.
This is who what? Order to, orders, 12.
Order 12 rule 6 Lordship. This is the recent, the same judgment was reiterated. In this judgment, this Uttam Singh judgment was reiterated.
Only fact, my lord, so it was decided only 3 days.
Lordship,
Very
first
so
of
we
all,
don't
I would
even
like to
answer.
also point out one thing. They had all the ample amount of opportunity at the time of hearing when this judgment was passed, prior to passing this judgment. And they have not
Just
objected it.
You see this property in Beltola, one katha,
One
30
katha 10.
lakhs. Come on.
Now crore.
No,
Now crore.
In North Guwahati, it is 1 crore.
No, Lordship, but the agreement, your Lordship, if your Lordship will look at the agreement, your Lordship will find out that.
Beg, I understand.
Yes, but there is no time bar in that agreement, and which they have admitted. That is why they have said that whatever the amount we have
If
received over
there
the
is no
years.
permission,
Yeah.
they should come to court within 3
And
years.
also interestingly, she has been taking money since the year 2013 till the year 2022. That is
Why they
admitted by
not
them.
come within 3 years? There is no permission. Why?
Why?
sitting?
First
Why
of all, they have
come
not
here?
obtained the self permission. Only
This
when
is
we
the
get
main
to know
fact,
that they have executed the
Not
another
a
deed
point.
of agreement, Lordship.
Hello, Plasma.
Another deed of agreement, then only we filed a suit. And also interestingly, Lordship, the execution proceedings, it was partly
I only-
executed. The personal
only
defendant
paid
number 2 and 3
50
have no locus standi in this
lakhs.
case anymore.
As per second agreement, 40 lakhs. They only paid 15 lakhs. Paragraph 12
First of
onwards,
all,
I have.
I would
denied.
also like to place one thing, Lordship, that this subsequent agreement and deed of agreement and the power of attorney itself is wrong, because if our agreement, first of all, they need to cancel our agreement if they want to enter into agreement with another person.
Their case, act
Because
is
our
fraudulent
agreement
act,
was
my lord.
still alive.
Fraudulent statement, fraudulent act. They
It
enter
was
in the
reflected
agreement,
in
now
the
say.
record. Record will say
what is
everything,
this, my
Lordship.
lord? There should be some.
Record will say everything, Lordship.
Fairness, my lord. We are the advocate.
Even they
We should submit
they-
fairly.
They intentionally omitted the last page of this compromise deed in the Lordship's
Third party enter here, my
copy
lord.
also.
Like
If your Lordship will
some
find
legal
that in my compromise deed, the last copy I have annexed, the signature of their advocate is there. But in the appeal memo, that page is omitted, intentionally omitted, Lordship. The Lordship can see who is trying to mislead the court.
That I have not noted down, I may forget, I don't know. But I'll go through your.
Yes, Lordship, everything is written.
I'll go through your objection.
Objection.
After affidavit. I think I cannot, nothing more will enter into my head. 2 arguments I have heard. That to,
and that
in RSA and RFA.
and
So
that
nothing more I can take in, I think.
that subsequent agreement, my lord, executed after filing of the written statement. That may be.
But
When I
your
filed written
Lordship may
statement,
kindly
there is
say,
a-
that
I
agreement,
forget
your
what
Lordship cannot.
Now, And then I'm talking about other parties.
Yes, ma'am.
So I won't be able to absorb anything more.
Lordship, one thing, if they are pressing on this,
I
which
won't
means
be able to take.
My lord, I'm-
Now whatever you submit, no, it will not be recorded. I won't record it and I will forget it.
if your lordship allow, I will also submit my written submission by tomorrow in this case.
No, written submission, then you'll also have to give him a copy and you'll also have to reply.
I have nothing to say, my lord. Within 3 days, case is decided, your lordship may return back the.
Your lordship
demand
can
the
kindly
matter,
see
this
the
matter.
dates and everything. It is all everything there in the record. Your lordship will go through the record and
Then I'll go through the records and I will decide
My lord.
because
correctly or
that
wrong.
power is there
We
with
will
the,
accept, we will accept.
that
whatever.
power with there is
We
the
are,
power.
we will have it.
No,
If-
no, why should you accept?
Now, if your lordship dismiss it, then you will also be allowed, then you will also have. As a lawyer, we are always happy, my lord.
Accept. You must
Yeah.
always,
We always happy, my lord.
you must always contest, not accept.
My lord.
And then anybody else left, I won't be able to take in any more argument. 2 arguments, RSA and RFA. Just imagine,
My lord.
will I be able to absorb any more?
My lord.
So I'll give you a date, okay? Anybody sitting behind?
No, those are my,
No, no, oh,
those are my children.
Okay, okay. So I was addressing them all the time. But you were submitting what to do.
Oh, they are my children.
Oh,
Item 14, man, it may be taking another day.
yes, yes.
Lordship, can it be on Thursday, this Thursday?
No, not
We have some kind of
Thursday,
urgency,
maybe on, maybe next week,
Then Tuesday.
4th September. Already I have given Thursday time for hearing.